Just wait. For pronouncement of judgment, item 48.
We have affirmed the judgment of the CAT and issued certain directions for implementation of it.
Adjournment request, if any, from item number 1 to 6.
Lordship, in item number 1, Lordship, we have filed one affidavit in opposition yesterday. Lordship, it may be permitted to be called for, Lordship. Item 1, Lordship.
Item number 8 to 15.
May I please, your Lordship? Lordship, with the consent of the adversary, I beg to mention item number 8 of the daily list, Lordship.
Item number
8, Lordship.
8.
I have already circulated the adjournment slip also, Lordship. Senior Counsel, Mr. S. Dutta has some personal difficulty today, Lordship.
8 and 9 both are
Yes.
connected.
Lordship, yes.
6 weeks.
6.
Yes. Yes, 6.
Deep-
May I please, your Lordship? With consent of the opposite parties, I prefer an adjournment in item number 10 to 13. Thank you. My lord, we have some difficulty.
Who is for the other side? Have you informed?
I mean, item number 11, madam.
You are for the appellant.
Yes, item number 11.
Who is for the other side? Appellant, it's okay, but who is for the other side? Respondent side. You are for the respondent.
Yes.
Okay. Adjourn.
Okay.
Please, Your Honor, my lord, for tagging my affidavit which I filed yesterday, along with my items which is called today.
What about it? Want to bring on record, no?
To bring.
Which item? Which item?
Your item, please.
Items 17, 18, 19,
17, 18, 19. You have
Yes.
filed an affidavit, we have to call it.
yes.
Call that.
Lordship, I beg to mention one matter regarding PIL Lordship may be listed on 6th of this
What's the urgency, madam?
urgency regarding the issue related to women related issue, Lordship.
Women related issue.
Yes, Lordship.
Why not next week?
This is the urgent matter because the highest number of that is rape case in the state of Assam as well other state also. That is why I want that early, because I have filed the petition on 28th of August, Lordship.
Next week we'll list it. Next week.
Lordship, kindly
Next week.
13th, Lordship,
13th, okay, 13th.
13th of September. Public.
Adjournment request from item number 16 to 25.
Wait, please, your Lordship. I beg to, with the consent of the other side, I beg to mention item number 25.
25.
25, Lordship.
You are for the respondent.
Respondent, Lordship.
And for the appellant. And for the appellant. No objection. 8 weeks. Yes.
Obliged.
I don't 21, my lord, 21, my lord. I'm on behalf of RK Deputy Solicitor General of India, my lord. I'm going to mention, my lord.
Petitioner in person.
Yes, my lord. My lord.
However, on the last occasion, they took the time for
My-
2
my lord,
weeks.
only, my lord, this that may fix on 6, my lord. He's out of session today, my lord. 6 of this month.
So, Your Honor, my humble prayer would be
Highly.
Okay, six.
So my lord, yes, I'm fine and okay with that. But my lord, my humble prayer would be, since this is a very long pending matter, so let this matter be fixed on 6 for a full length hearing and disposal. For necessary
Mentioned,
disposal.
it is already listed in hearing,
Yes,
so it supposed to be full length hearing.
yes, yes.
So it is there.
So on 6th, it may be taken as a full length hearing.
Madam, all the
Yes.
cases are here for full length hearing, no cases for part hearing. Here.
I would like.
Mayor Priya Losip, with the consent of the petitioner, I would like to make for an appeal for adjournment of item number 23 and 24, this please.
23 and 24.
Yes. Both connected. Next.
From item number 26 to 34.
Lordship, I beg to mention item number 14, Lordship.
40,
1-4, Lordship.
144.
Yes, Lordship.
Yeah, what do you want?
Lordship, matter may be possible for today, Lordship.
Adjourn.
Hello.
Any other request?
Thank you, Lordship. Lordship, in regard to item number 26, which is tagged with item number 27 also. I have,
26.
yes, I have,
27. Yes,
I pray for an adjournment in this case.
you are
Lordship,
for?
Yes,
repeat-
respondent, my lord.
private
Answer
res-
appeal.
all the private respondents.
Adjourn.
Well, only date may fix, my lord, days, my lord, this. My lord, October, my lord, 24th of October, my lord.
September last week.
My lord, September, no, my lord, October, my lord.
October.
Yes, my lord, we propose on 24th of October.
Deeply obliged.
Oblige.
Any other requests? Daily list for admission item 1.
David. I think.
Please, sir. Lordship, though I have given the background, but the bench was different at that day. So in any way, this relates to basically, I have challenged the order of London, this CAT tribunal, whereby the OA of the respondent number 1, who is working as a joint secretary in CBSC in Guwahati, was transferred from Guwahati to Thiruvananthapuram, which was challenged before the London tribunal, and the OA was allowed. We have challenged the order of the tribunal before this honorable court. The brief facts which are admitted from both the sides, admitted fact is that CBSC, the services are all India transfer services from the post of section officer and above. The respondent number 1 was appointed as section officer way back in 2002 and was posted in Guwahati in 2002. From 2002, with all his promotion till 2018, he was remained in Guwahati. From in 2018, when he was promoted to deputy secretary, he was, as a promotional transfer, he was posted to Patna regional office. After being there for 4.5 years, on his request, he was again taken back in Guwahati. From 2022 till date, he is working as joint secretary in CBSC in Guwahati and heading a department called Center of Excellence. The transfer, basically, the main ground which he has challenged is that he has been transferred in 1 year and 8 months. That is one of his main ground, that the clause which relates to having 3 years of services, posting at a place, has been violated. But our case is that it is not a violation of the clause because the clause itself says that normally one has to be for the 3 years in a post like this. However, subject to the administrative exigencies and public interest. So our case is basically it is not in violation. It is in consonance with the clause. The other grounds which he has taken and during the proceeding before the learned tribunal, a ground and which was there in the impression of the tribunal also that he has been transferred to a very far off place from northeast to southwest, from Guwahati to Thiruvananthapuram, and on the basically indulgence of this that the Dalan Tribunal, we had taken instructions from the CBSE chairman. I interacted with him that if he could be accommodated at any other place, because there was a mass transfer of 72 officers on the day this impugned transfer order was passed. So the CBSE reconsidered and made a decision to transfer him to Ajmer, Rajasthan. And we have put on affidavit before the tribunal that instead of Thiruvananthapuram, we require the same post in Ajmer. So therefore, we are ready to accommodate. We have passed order also. But as this matter is pending, therefore, we have not issued a formal order because that will amount to basically interfering with the administration of justice and during the pendency. We never wanted to do that. So we brought by way of an additional affidavit this fact that we have decided to transfer him to Ajmer. Because one of his grounds was that he is a joint secretary and the post to which he was being sent, though he was sent as a joint secretary to Thiruvananthapuram, but he said that on that post, in that place, there is no post of joint secretary. So we have taken that also into consideration, and the post of joint secretary is there in Ajmer. So even that impression which he was carrying that he is being basically discriminated was we have taken care of. If Lordship, I'll just take Lordships to the relevant clauses which are not just 2 in number, which starts from page 130 of the paper book. Lordship has that?
Yes.
Page 130, if Lordship could see clause 1.1, then only 3 clauses are relevant for the purpose of adjudication of this case. Lordship may have 1.1. All the employees of the board, including heads of the department in exceptional circumstances. This exceptional circumstances is attached to the word head of the department. The head of the departments are directors who are mainly based in Delhi. So therefore, it is that all the employees of the board, including heads of the department in exceptional circumstances, but not including the officers posted on deputation to the Board of Government of India, are liable to be transferred anywhere in India in board offices units at any time in administrative exigency and in public interest only except in the regional office having jurisdiction over the district of their declared hometown. There are 3 exceptions to this clause. Lordship may have this. The first exception that you will not post it to a place in regional office where your declared hometown is. That is the first exception. Second exception is that if you are in deputation, you will not be transferred. The third is that if you are director, only in exceptional circumstance. Apart from these 3 exceptions, all the officers of the board are liable to be transferred anywhere in India, in any office, any unit, if Lordship may have this 1.1. If Lordship may have further, the next page, 2.1, which has been challenged and which says by the respondent number 1 that we are in violation. If Lordship may have that, 2.1, the next page, page 131. The tenure of regional officer, head of CO, which he is heading, shall normally, Lordship may have the word normally, be for a continuous period of 3 years term from the date of her posting transfer to a regional office COE as regional officer, head officer, a COE, except for administrative reasons in public interest. Efforts would be made to provide stability of tenure of regional officers, head of COE. So the dispute is with respect to this clause. They say that we are in violation. We are not adhering to the 3 years tenure which is provided. We say that though the tenure of 3 years there, which is normally, but in administrative exigency and public interest, we can take a call and can transfer a person before the tenure of 3 years. The only thing is that administrative agency or public interest must be involved. That is the point, Lordship. If Lordship may have in the same, Lordship, this, the next page, that is 133, which is 7.5. The last but one clause of this particular notification, if Lordship may have, this is the transfer policy. 7.5. Notwithstanding these guidelines, Chairperson CBSE shall be the competent authority to transfer any employee of the board for administrative exigency and in public interest over and above these guidelines. So the paramount thing is the administrative exigency and public interest. Lordship, I just bring to the notice of this Honorable Court that CBSE, which has pan-India presence, is catering to, and there are 30,000 schools which are affiliated to CBSE, and there are 40 lakh students which are basically appear for examination in class 10th and 12th respectively. This is the admitted fact. In view of this, Lordship, and Lordship must have, Lordship, come to know that recently there was a NEET fiasco. There was a leakage of question papers of medical examination which reached up to Supreme Court. And all over India, in Bihar, in Gujarat, and all other places in Haryana, there were issues relating to and the complaints relating to leakage of question papers. That also alerted, because we, apart from holding examination for a class 10th and 12th, we are also assigned to conduct examination like CTET twice a year and some other examination, and from time to time the government assigns to us. So we keep on holding examination. Because we are examination body, our main job is to conduct various examination in the country. If Lordship, in view of this fact, if Lordship may see, the transfer order, which is the impugned one, is at page 126. Just 4 or 5 pages before the Lordship, what I was pointing out is the transfer order under challenge. This is dated 2nd of July 2024. Lordship has that. If Lordship could see, right from 1 to 72, these all officers have been transferred all over India. Out of this, the concern of this court might be from serial number 3 to serial number 11, because they happen to be the joint secretary. Serial number 3 to 11 are the joint secretary, and out of these 11 joint secretaries, Lordship, 3 have been transferred to South Indian cities. 1 to Thiruvananthapuram, 1 to Vijayawada, and 1 to Bangalore. If Lordship may have 2 from Delhi and 1 from Guwahati, the present respondent number 1. Out of these 72, Lordship, it is a matter of record which has not been disputed that 19 officers have been transferred before the completion of 3 years. That is one fact I wanted to bring to the notice. 19 officers out of the 72 have been transferred before the completion of 3 years. He is not in a standalone case in any aspect, Lordship. First point, 19 officers have been transferred. Sorry.
Respondent number 1 is in Guwahati since.
He is Guwahati since in the present tenure from 2022 November.
No, overall.
Overall for 17.5 years since 2002. And he takes a plea in the counter affidavit that was the exigency of service. So therefore, I was kept here in Guwahati, and others who are being kept here for many years are not part of the exigency of service, and I am being transferred is not part of exigency of service. Anyway, Lordship may have this. In this particular transfer order, the certain facts which are very important are 19 officers of the 72 have been transferred before 3 years. there are 6 ST officers transferred. And why I'm mentioning this? Because he had taken a plea before the tribunal that I am being ST, being discriminated. There are 6 ST overall have been transferred. There are 5 officers from the Guwahati who have been transferred. He is not standalone an officer from the Guwahati who have been transferred. It's a major reshuffling. There are 11, there are, so Lordship, 9 joint secretaries who have been transferred. He's not alone a joint secretary who has been transferred. There are 3 joint secretaries who have been transferred to a far off, so-called far off places, which today in this age, the far off place has no meaning. Either you have flight of 1 hour or a flight of 1.5 hours or a flight of 2 hours. That is the only difference as on date. That whether you will take a 2 hours flight or 1 hour flight. Sorry. You people gave me instance like anything today.
Yes,
Please, Lordship may have another admitted fact is Lordship has at page 271, which is the personal file of the respondent number 1 at the time of joining CBSE in 2002. Page starts from Lordship page 268 and the relevant is 271 and 272. So 273. What I'm trying to show that Lordship 94 to 2002 till he joined CBSE, he was assistant in Assam University, posted at one place.
actually, university employees are not supposed to be.
So he chosen to join CBSE, which he knows that a post he is going, basically a post which is drawing is which service he is joining, which is has all India basically transfer policy. If Lordship could see, he was from 94 till 2002, he was in Assam University. Page 273, his wife was working at that time also, she was a lecturer. Because he has also taken an spouse ground that my spouse is working in Guwahati, so therefore I should not be disturbed. So the four grounds he has taken that I have been transferred before completion of 3 years. On the spouse ground that my wife is working with the Department of Textile. Sorry, that time she was working somewhere else. Today, what they have stated that she is working in the Department of Textile. And my girl child is starting in class 8. And I am having not a very good health. My wife is also not having a good health. These are 4 grounds mainly they have taken. In the OA, the pleadings with respect to Malafide was as vague as the other side can imagine. It was vagueness to the extent that I am ST, I am being victimized. I had filed certain OAs earlier, though no OA is pending, that I have been punished. And my hometown is Guwahati, and you have changed your transfer policy where you have excluded the hometown, you have included a hometown clause. So this change in policy to victimize me only. I can't go to that extent that an employee is saying that you have brought a new transfer policy to victimize me. And a ground is taken, there are 2-3 employees in Delhi who have been working for 5-10 years and they have not been transferred. So I am being victimized. The negative comparison. So these were the grounds for Malafide taken in the OA. When I filed my reply, they started changing the ground of Malafide, saying that out of the 72, there are 24 instances where the people have been kept in the same city, or they have been changed from Noida to Delhi, Chandigarh to Panchkula, Panchkula to Delhi, to a very nearby places, and I have been sent to a very far off place. So this is basically a hostile discrimination, violation of Article 14, the stance changed. Now in the counter affidavit, a further stand is taken that, as you say, because Lordship, what had happened that right from 2002 to 2018, he was not transferred anywhere. In 2016, a transfer was made, which he challenged, he won, we did not challenge that. Only when he was promoted to the post of Deputy Secretary, he was sent to Patna. So therefore, it was a promotional transfer. So we say that, technically speaking, this is his first transfer in his career of 22 years, and maximum could be said at second transfer. Had that 3 years policy would have been strictly applied on him, then this would have been his at least 7th or 8th transfer in his life. But he says that that is what the exigency. Lordship, what if Lordship could have straight away to page 84, which is part of the impugned order passed by the learned tribunal. Page 84, I'll read para 8, Lordship.
Yes.
Which is the discussion after recording the submissions of the parties.
Yes.
If Lordship may have para 8, page 84, running page 19 of the order. As per the settled principle of law, transfer can be interfered. Only one of the following 3 grounds are violated. 1. Transfer order issued by an incompetent authority with no locus standi. The tribunal has reached to the conclusion that it has been passed by a competent authority, so I'm not touching this. The second and third, transfer order made in contravention of extant statutory rules, orders, rules, and transfer policy. Transfer made on Malafide grounds. The ground 2 and 3, the ground 2 is to some extent is correct. To some extent it is wrong. To the extent that if it is only in violation of statutory rules, not the guidelines, not the administrative orders, even if it is in violation of administrative orders or any guidelines, it is a plethora of judgment of the Honorable Supreme Court said that will not give you any right to challenge your transfer unless you show that it is in violation of statutory rules. So to that extent, I'm saying that it is right and wrong. The third is Malafide. And Lordship could see what basically the discussions which have been made. I will, examining objectively the above 3 grounds, is transpired that only one ground, transfer order issued by an incompetent authority, has not been violated in this present case. The impugned transfer order dated 2nd July 2024 has been issued by Mr. So-and-so Secretary CBSE with the due approval of the competent authority of CBSE, Chairman CBSE. Thus, the transfer order of the applicant is legally tenable in the eyes of law. However, Lordship, these 2 pages, 3 pages are very important. However, as far as the second pillar of violation of statutory order and rules and transfer policy is concerned, it is seen that there has been a violation of the CBSE transfer policy in this case. As per para 2.1 of the transfer policy, an officer should ordinarily serve on a posting for at least 3 years. In the instant case, the applicant had joined as head of Center of Excellence, Guwahati, on 9/11/2022 and has been abruptly transferred to Center of Excellence, Thiruvananthapuram, after completing only 1 year and 8 months. There appears to be no administrative exigency or public interest served by abruptly aborting the 3 years tenure of the applicant and transfer him to Center for Excellence, Tribunal. Lordship, I'll pause for a minute here. Lordship, it doesn't lie to the tribunal to say and observe that there is no administrative exigency. I have in my affidavit in so many words, unless you find something very perverse, what I found a law that they have to show a Malafide. The moment there is a Malafide, the administrative exigency goes. But the moment they are unable to show and prove the Malafide, the administrative exigency is presumed. That is the law. So the onus is on them to establish and to show to the court, though Malafide is one thing, which is very hard to prove beyond reasonable doubt. The court says that if you able to show to the court the material available, then an inference can be made that whether there is material for Malafide or not. That is a settled law. I'm not asking that you must prove beyond reasonable doubt as we do in the criminal cases. But unless the Malafide is there, if there is no Malafide, then exigency is presumed. So therefore, it doesn't lie in the tribunal to say and observe without discussing anything further that there is no administrative exigency.
Yes.
Click. I'll read further, Lordship. In the same page, page 85.
Yeah.
Before that, I'll just, Lordship, say that there is an observation that there is a violation of 2.5, 2.1. I said that it is in compliance. The Lordship has to see that if we take the recourse to that normally and the word except in administrative exigency, then it is compliance and not in violation, to my mind, with great respect, Lordship. Had it been a non-obstante clause and an absolute clause that what may come, there has to be a 3 years tenure, I would have been out. But the moment it is subjected to the provisions of administrative exigency and public interest. And if I say so in affidavit and explain it, though under the law, I am not obliged to explain all the administrative exigencies which I have, requiring all these persons to be transferred is not the legal obligation. But as the tribunal wanted me to explain, I've explained in my affidavit and I'll show also. But Lordship, before that, page 85, I'm reading further, that the learned counsel of the respondent's argument that being a joint secretary level officer, he would serve the interests of the Center of Excellence Trivandrum better cuts no ice, as by this transfer order, Center for Excellence Guwahati interest would suffer when the private respondent Shri Arvind Kumar Under Secretary joins from Patna. I again say, it doesn't lie for the tribunal to observe that when the best interest of the organization will be served. Whether it will be served when he is here or whether it will be served when he is there. It doesn't lie, Lordship, with great respect. Also, this transfer order violate DOPD transfer guidelines that as far as possible, husband and wife should be posted together. Applicant's wife is teaching an Assam Textile Institute, Guwahati, and transfer should not be done in the academic mid-session of school-going children. Applicant's daughter is studying in class 8th in a school at Guwahati. Lordship, the two things, despite the fact that the tribunal records as far as possible is flexible enough to accommodate all, to reject or to consider and to go overall view as to whether we had been considerate enough for 17 and a half years for this respondent number 1 is concerned. Right from 2002 to till 2018, he was in Guwahati. When he was sent for 4.5 years to Patna, again called back to Guwahati. So as far as possible has to be seen in perspective.
You have already mentioned.
Yes, If Lordship could see further, that say that the class 8th student studying, my point is basically the CBSE has a clause in their own bylaws that any children of any officer.
That is practically not possible, sir. Eighth-
No, what I'm
eighth-
saying,
Eighth standard student, you say that he can shift his daughter to his place of posting, that is not.
and I
That's
can
not
understand
quite-
that if somebody's board examination 10th and 12th is just there on the anvil, the 3 months or 4 months of board examination,
then-
one should not be disturbed.
Don't stress.
And it is
on
very
this one
subjective
much.
thing.
Don't stress on much this, that transfer of violation policy, this transfer in violation of the policy, you mean to say that is not liable to be interfered only on this ground until and unless it is in violation of the statutory routes. That's
Yes,
all.
yes. Please, Lord, I'll read further. I'm really thankful, Lordship.
Fine.
The third pillar, Lordship, this is very important. The third pillar in the 6th line of this page of 86, Malafide also appears to be proved in the instant. What is the basis, Lordship? I ask a question to myself. What is the basis of the tribunal to reach to this conclusion that Malafide also appears to be proved?
That they, in the further lines, they.
It is seen that in the impugned transferred order, there are many officers who continue to be posted in Delhi, transferred from one place to another post only, and transferred to nearby places of their old posting, Delhi to Noida or Chandigarh to Panchkula. Lordship, this is not. In the instant case, the applicant has been transferred from Guwahati to Trivandrum, a very far off place. But this
Thus, there appears.
thus appears to be hostile discrimination. Lordship, I can understand. That's why I had shown on the very first instance, there are this 9 joint secretaries. Out of that 9, 3 have been sent to South India. And it is, Lordship, not the place. I have annexed.
That you have already argued. Now, you mean to say that violation of transfer policy is not a ground to interfere with? And there is no, he has failed to.
At the
prove any
first place,
malafide.
my argument is there is no violation.
And
There is no violation.
And so far as regarding Malafides is concerned, the finding of the tribunal that the Malafides appears to be true is absolutely without any basis. That's all.
Lordship, but what point they have also raised in their basically OA, they say that this post which they are holding of Joint Secretary COE,
That has not been discussed and touched upon by the tribunal.
but they have taken in so many words in the counter also.
Whatever it may be, the tribunal is not swayed by that argument that he was not given.
He
a
was not in
posting.
administrative cadre.
Whatever. it
I
may be.
must inform this honorable court that this cadre
Sir,
system
the
in
only ground on which the tribunal has interfered with the transfer is violation of transfer policy and Malafides. That we
both
have to
are
say.
equally vague in observation. This is my humble submission. And I'm
What
saying,
about the administrative or he is holding an administrative post or academic post or whatever it
A
means? That
cadre-
has not been
This-
touched
but
upon by the
just for
tribunal,
just for
therefore-
Lordship, this academic interest, I would say that CBSE introduced this cadre system as late as 2017-18 in order to streamline the entire structure. But Lordship, out of the around 17,000, there are only 10,000 employees at present. The most of the vacancies are there in the this academic cadre. So therefore, the personals from the administrative side are being
So
sent to
assigned
this.
duties of the-
And I have seen the chart, there are 67% vacancies that side and 16% this side.
Mr. Miyagi, we don't want to go into all this. Since the tribunal has interfered with the order on 2 grounds, we have to see whether these grounds are available or not. That's all.
Please, Lordship may straight away have to come to my Lordship, the 3 paragraphs which I have stated in my affidavit with respect to the administrative exigency.
Okay, fine.
Please, Lordship may have that. If Lordship may have page 230. I'll just read 3 paragraphs and I will, Lordship, rest my hour. Page 230 is part of my affidavit which I had filed before the tribunal. I've annexed the entire pleadings filed by them as well as our side. Page 230, Lordship.
Yes.
Please, Lordship, I'll start from 230 para E, small e. Several officers in the impugned transfer order were relocated before completing their normal 3 years tenure, for instance, so and so, so and so. Next para. That the chart prepared by respondent CBSE with respect to all the officials mentioned in the impugned transfer order would establish that the transfer order is the mixture of routine/rotational transfer done in administrative exigency and in public interest, and transfer done in terms of clause 1.3 of transfer policy regarding the declared hometown clause where the jurisdiction of RO exists. This clause was not made applicable to him because he was not working in RO. Copy of the chart so and so. The transfer of the applicant has been done in administrative exigency and in public interest, keeping in mind the organizational need and efficiency, optimum resource allocation, and meeting the dynamic needs of the organization. Apart from the 2 transfer order dated so and so, there are more transfers on the anvil, which would again be a mixture of routine, rotational transfer in administrative exigency and public interest, exceptional transfer in public interest, etc. NEET fiasco, leakage of papers in UG medical entrance examination has rocked the entire country. Even the incidents of question paper leakage malpractices in examination center have increased in the recent past.
I think, sir, Nehaji, once you have already argued that you need not to explain the administrative exigencies, even though if you have explained that, what is the point in?
I'll just explain in few words
You're
without.
over arguing your case, Mr. Niaji. I'm sorry.
Please, sir.
You're over arguing your case. You made your
Lordship,
point.
I think it should not have reached here, this code, this matter.
These are the 2 points, on which the tribunal has interfered with. We have to see whether these 2 points are available or not. That's all.
No
This
problem.
is what the-
No
yes.
problem, Lordship.
Yes.
I have prepared the written argument also, I've prepared the judgment also, I can give that.
Okay, relevant 1 or 2 judgment, not more than that. We don't want to deal this plethora of judgments that the Supreme Court in 1991 and Shilpi Bose and then thereafter that we don't want that. You give us the relevant judgment, we'll consider. And 1 judgment is enough for that purpose. I think so. If the Supreme Court judgment is there, it is a law of the land.
Lordship, I'll give this and I'll say that only serial number 5 is relevant.
That's all.
I will not say much because it will be difficult for me to take out the judgment. I'll just give this. So that
Number
also,
5, yes.
because objection to the extent has been taken that the authority letter filed to file this writ petition is also not correct. The person who has filed is not the competent person.
Yes.
But I'm really thankful also for the patient here.
May it please the Lord. My Lord, the admitted position is,
But, Mr. Chaudhary, just before you start.
yes,
We would like to hear you on these 2 points. If there is a violation of the transfer policy, the court can interfere. And in the facts and circumstances.
I'll only refer to that.
Malafides.
No, I'll only refer to the first point.
And just one more addition to what my lord has said.
Yes,
In page number 87,
yes,
para 11. Applicant is allowed to continue for eternity. How long?
page 87, my Lord.
Para 11.
Is a merit disappear allowed, posting. No, my Lord.
Mr. Niaz, sorry. Mr. Niaz has argued on so many things, but this, according to us, was a very crucial factor.
No, my
The
Lord.
order is flawed. on
I'm
this.
not seriously on this point. I'm on a slightly different tangent altogether, my Lord. My Lord, kindly take note of one date. From 2018 to 2022, I was in Patna. Then by order dated, my Lord, 9/11/22, I was transferred to Guwahati. And I am sought to be now transferred by the impugn order to Tiruvananthapuram. Now, my lord, just to build my case, if your lordship would kindly come to the transfer policy at page 130. I may have your lordship's kind attention to page 131.
Yes,
Page 131, Miller.
131.
Yes, clause 2.2, 2.1. The tenure of regional officer, head of COE, shall normally be for continuous period of 3-year terms from the date of his or her posting, transferred to regional office, COE as regional office, except for administrative reasons in public interest. So one exception is in administrative exigency. This term of 3 years can be truncated also in an appropriate case. Now, this is very important, my lord. Effort would be made to provide stability of tenure of regional officer, head of COE. So what the transfer policy envisages is, my lord, normally it is 3 years, but in case of administrative exigency, it could be curtailed also. However, efforts should also be made to ensure stability of the tenure. In other words, as far as practicable, my lord, that 3-year tenure should be adhered. Now, 2.2 is very important.
Fine.
All Group A and Group B officers on sensitive post shall mandatorily be transferred, rotated after every 3 years from their respective posting assignment to any other department, unit, regional office, COE. That means, my lord, a person who is holding a sensitive post, he has to be mandatorily transferred out at the end of 3 years. That's their professed policy. Now, my lord, what is that sensitive post? Please come to, my lord, page 328. Page 328.
Yeah.
It's a office order dated 25th of March 22. It is notified that the following posts have been identified as sensitive posts in CBSE headquarters and different unit offices of CBSE. The officials posted in below mentioned post will be subject to transfer rotation as may be feasible in accordance with the extant instruction of the relevant authorities on this subject. Lordship may skip that headquarter office. Please come to the regional office. So in the regional office, my lord, regional officer, irrespective of level, he holds a sensitive post, joint secretary all posts, deputy secretary all posts, executive engineer, junior engineer. So I do not fall in this sensitive post category. So there was no compulsion on the part of the CBSE to transfer me out even on the end of 3 years also. That's the policy, my lord. That's the policy. I was on the center of excellence.
Mr. Chaudhary.
Yes.
We have a query. You will appreciate that for a employee, particularly in governmental departments, the expression transfer has two components. One is transfer from one department to another, and the other is posting, which requires a physical shifting, relocation. So the orders of transfer are normally assailed and examined, and the policies are framed to ensure that employees are not harassed by frequently shifting them from one place to another.
Yes.
Perhaps you will agree with us that when this expression transfer comes in, what brings with it is the posting.
Of course.
Is it that your client has not spent 3 years in Guwahati?
No. No, earlier he spent.
No, no.
On this occasion, no, my lord.
Then before this transfer order, he was posted as?
No, I came to Guwahati. I was in Patna.
came to,
On November 22, I have completed only 1 year and 8 months.
all right,
I have not completed 3 years.
all right.
What I was trying to, by referring to the transfer policy, what I wanted to argue was, my lord, that not that at the end of 3 years I have to be transferred out. Because I was not holding a sensitive post, they're under no obligation to transfer me out even at the end of 3 years. I was just arguing on that aspect. It's not, I have not completed 3 years.
No, but they can transfer you.
Yes, in an appropriate case, yes, my lord. End of the day, administrative exigency, yes. But that administrative exigency, that must not be the ipsi dixit of the authority, that the record must reveal. My lord, lordship knows the practice of this court. In case of suspension, transfer, lordship always examine the record. The decision-making process was contained in which file? That file will reflect what was the administrative exigency. We are not arguing anything beyond that. Affidavit, my lord, we say so many things. Affidavit is not the ultimate thing. Ultimate thing is the decision-making process is contained in which file. That will reflect how the administrative exigency aspect was dealt with. So they are bound to produce the record. It's a certiorari proceeding. Supreme Court is admin to us, na? My lord.
Yes.
My lord, the long line of authorities, the Honorable Supreme Court had said, my lord, that normally this transfer policy is not per se enforceable. However, my lord, it confers a legitimate expectation on the part of the government servant that in the normal circumstances it will be followed. If they want to deviate from the transfer policy, they must come up with some good reason. And that is what the Government of India Ministry of DOPT also envisages. We have annexed that, my lord. Please come to page 337. To obviate, my lord, to arbitrariness, these guidelines have been laid down. Please come to page 337. Page 337. The undersigned is directed to refer to OMs of event dated 13th of June 2014 and 31st of July 2014, wherein all ministries, departments were requested to prescribe minimum tenure, set up mechanism to akin to Civil Service Board for recommending transfer, and place in public domain the transfer policy. The rotational transfer policies should aim to harmonize objectives of institutional memory, avoid development of vested interest, and provide exposure to employees of working in different organizations, inter alia ensuring overall growth of an officer. Transfer policy should provide both a minimum as well as maximum tenure. As transfer before completing the minimum prescribed tenure or stay beyond the maximum tenure should be with the approval of the committee constituted for the purpose, for reasons to be recorded in writing. I am on this, Miller. So this will ensure fairness in the decision-making process. So, my lord, the doctrine of legitimate expectation, it may not give us relief straight away, but doctrine of legitimate expectation, my lord, at least ensures as a fair dealing. A division bench of this honorable court has very lucidly dealt with in this aspect of the matter, my lord. What is the right which flows from a transfer policy? Yes, it's not per se enforceable, as Supreme Court has said, but it confers a legitimate expectation that the officer's right will be dealt with fairly. Now, how that fairness can be ensured? By recording reasons. Now, my lord, for example, I have in the affidavit, we have brought out facts, my lord. In India, I am told there are 19 regional offices, out of which 12 offices, there are no joint secretary level officers, my lord. And they are talking of administrative exigency. My lord, that's why I said it cannot be the ipsi dixit of the officer swearing the affidavit.
Just one.
In notice. Be there for 28 of 28 of para 28. It took 2013, 15 SCC, na? 7-3. Yes, my lord, in this regard, we are relying upon the decision of the Supreme Court, which is the next, my lord. If your lordship would kindly come to page 207. It's my lord, 2015, 2013-15 SCC 742, 73. Please come to page 207, my lord.
2000,
Page 207, my lord.
no,
The citation is, my lord, 2013,
15
15 SCC 732.
732.
Yes. And the, my lord, we have annexed that copy in the paper book, it is there.
Acha, paper.
Yes, yes.
Okay, 207.
Yes, that is where, my lord, it starts earlier, but I'll have your lordship's kind attention to para 29 and 30, 28, 29 and 30 at page 207 and 208.
Just a minute. Yeah,
Uh,
yes, Subramaniam.
Yes, TSR Subramaniam. CSB consisting of high-ranking in service officers who are experts in their respective field, with cabinet secretary at the center and chief secretary at the state level, could be a better alternative to guide and advise the state government on all service matter, especially on transfer, posting, and disciplinary action, though their views also could be overruled by political executive, but by recording reasons, which should ensure good governance, transparency, and accountability in the governmental function. Parliament can also, under Article 309 of the Constitution, enact a Civil Service Act, setting up a CSB which can guide and advise the political executive, transfer and posting, disciplinary action, etc. CSB consisting of experts in various fields like administration, management, science and technology could bring in more professionalism, expertise, and efficiency in government functioning. We therefore direct the center, state government, and union territories to constitute such board with high-ranking service officers who are specialists in their respective field within a period of 3 months, if not already constituted, till Parliament brings in proper legislation in setting up CSB. We notice that present civil servants are not having stability of tenure, particularly in the state government where transfer and postings are made frequently at the whims and fancies of the executive head for political and other considerations and not in public interest. Necessity of minimum tenure has been endorsed and implemented by the union government. In fact, we notice that amongst 13 states have accepted the necessity of minimum tenure for civil servants. Fixed minimum tenure would not only enable the civil servant to achieve their professional targets, but also help them to function as effective instruments of public policy. The repeated reshuffling transfer of officers is deleterious to good governance. Minimum assured service tenure ensures efficient service delivery and also increase efficiency. They can also prioritize various social and economic measures intended to implement for poor and marginalized sections of the society. We therefore direct union government, union territories to issue appropriate direction to secure providing of minimum tenure of service to various civil servants within a period of 3 months. But this is an aspect, my lord, Honorable Supreme Court was also seized of and has expressed its view, my lord, of having a minimum tenure. Now coming to the facts of this case, my lord.
This violation of transfer policy can be a ground for interference. Any law on this point?
Yes,
Yes.
our division bench judgment. my lord.
Okay.
Come to hold.
If it is violation. If it is violation.
That is their argument, and yes, we deem it, it is in violation of transfer policy. We deem it.
My lord, this is,
Copy, sir.
we don't have the practice of giving copy, we give the citation. 2024 1 GLT page 1.
Yes.
My lord, lordship will kindly come to para 12.
Well,
At page 7 on the right hand side, my lord, fourth line from bottom of para 12.
If I may have the copy, sir.
It was further held,
Excuse me.
Huh?
I have the copy, sir.
no copy. It is, I've given you the
It's very
citation.
strange. A senior advocate is saying that you are not entitled to copy.
No, I'm not saying not entitled to, I'm saying in the practice in our court is we give the citation.
okay, fine.
Citation is 2024 1 GLT 1. See, there is nothing peculiar to senior advocate or a junior advocate. Everybody is an
It's
advocate.
very,
Uh,
I'm sorry to say this.
Even I'm sorry to say.
Yes,
It was further held that requirement of due consideration of legitimate expectation forms a part of principle of non-arbitrariness, which is a necessary concomitant of rule of law. Finally, the Honorable Apex Court held that though transfer policy may not be enforceable in law, but where such transfer policy has been framed, every officer will have a legitimate expectation that such a policy would be given due weightage when cases of transfer of officers are being considered. Then my lord will kindly come to para 25, my lord. Yet another at page 10, my lord.
yes.
Yet another aspect of the matter is that transfer policy as discussed herein above was formulated to regulate the transfer of government employees in education department of the state of Arunachal Pradesh, which covers all administrative cadres, including principals and directors. Such policy included tenure of posting as 5 years and also includes different conditions, considerations of transfer, including hard posting. In case of Registrar General High Court of Madhya Pradesh, it was held, though such a policy and guideline do not create enforceable right, but employees shall have legitimate expectation for proper implementation of such a policy, and that though such a legitimate expectation is not by itself a distinct and enforceable right, however, failure to consider to give due weightage to it may render the decision to be arbitrary. In the considered opinion of this court, in the given facts of the present case, the above decision squarely covers the controversy at hand, inasmuch as appellant was transferred and posted over giving due weightage to his request, including his date of superannuation. However, while transferring back, as reflected in the record, no consideration under transfer policy was made, nor any exigency of service are discernible for such exercise of power, and therefore such exercise of power is nothing but an arbitrary exercise of power. The Honorable Apex Court in case of so-and-so, reported in so-and-so also expressed the view that though the transfer guidelines are advisory in nature, however, same may be judicially reviewed when deviation of such transfer involves arbitrariness or discrimination. Surprisingly, in the case in hand, not to say the enforceability of any guideline or policy of transfer. All transfer orders, including transfer order under challenge, were not initiated on the basis of policy of transfer guideline, and also not by the administrative department on its own, rather at the behest of different political entities, including MLAs and advisors to different ministers. The appellant who was already transferred on his request is having a legitimate expectation to continue in his transferred place of posting, in as much as he is at the fag end of his career and transfer policy permits such a transfer. However, he was suddenly transferred without any proposal being mooted, and in the aforesaid background, this court is of the considered opinion that such order of transfer is neither issued in the exigencies of service nor in the public interest. Rather, the same is a result of arbitrary exercise of power.
Yes.
So, my lord, the principle of law which is deducible from the judgment is, my lord, though it may not be enforceable stricto sensu, but nevertheless, my lord, it ensures transparency in the decision. That's why I'm making this submission. The other day also I made this submission, my lord. Let the records where this transfer was initiated be produced before this honorable court to disclose what was that administrative exigency. End of the day, my lord, there has to be an application of mind of the some competent authority that so-and-so is to be transferred to so-and-so place. Very well, you are competent to do that. But you must at the same time disclose the reason, because you are truncating my tenure, which is being given to by the policy. Therefore, my humble submission is, my lord, yes, may not be for the said very reasons, but certainly, my lord, this is a case where lordships will not interfere. And para 11, my lord, that is, it can't be our cup of tea, my lord. I have a right only to complete my tenure. That's my only prayer. After end of the tenure, my lord, they are at liberty to transfer me. That is my humble submission.
Now this, we are hearing it finally.
Yes. No more
Only
argument.
one-
Finally, with this understanding, we are hearing it.
Yes. Lordship, only one point on this. If Lordship had asked a very pertinent question, can you show a judgment which says that if there is a violation of transfer policy or administrative reason, the court can interfere? If Lordship could have the compilation which I have given, the Supreme Court judgment, one paragraph. Although my case is that it is no violation, but assuming it to be, suppose I
All the-
go by
you are
this, that it is,
You are referring to all these judgments?
no, one para 3 lines, page 90.
9-0.
Please, Lordship, this is the celebrated judgment, which is S.L. Abbas judgment. I can give my copies here today.
9-0. Yeah,
Lordship, 90 para 10.
yeah.
Then only read this. The said observation. You can have, sir.
No,
please.
thank you. I don't need.
No, I can know first.
No.
We have the,
L1.
we, in our bar, we always explain. Anyway. The said observation, in fact, tend to negative the respondent's contention instead of supporting them. The judgment also does not support the respondent's contention that if such an order is questioned in a court or tribunal, the authority is obliged to justify the transfer by adducing the reasons thereof. It does not also say that the court or the tribunal can quash the order of transfer if any of the administrative instructions, guidelines are not followed, much less can it be characterized as Malafide for that reason. So therefore, even if there is any violation of any guidelines or instructions, the violation of only the statutory orders are one of the grounds in the limited jurisdiction of judicial interference is a ground to challenge the transfer. And Lordship, the writ petition which I have filed, in this one line, I'll just read, Lordship, which is the judgment cited by the other side also before the tribunal, page 403. 2 lines only. I'll not trouble Lordship reading the entire judgment or plethora of judgment, only 2 lines. This was the judgment cited by the other side, page 403. I'll just read the second paragraph, which also on the basis of the various Supreme Court judgments, this judgment, though Lordship is passed by the tribunal, Lordship will have only a persuasive value. In para 3, I will just read, Lordship. It is true that scope of judicial interference, I'm sorry, Lordship has that?
Yes.
It is true that scope of judicial interference in the matters of transfer is very limited.
Para 3.
Lordship 1, 2, 3, page 403. it is unnumbered.
403, yeah.
It is true that the scope of judicial interference in a matter of transfer is very limited. The tribunal can strike down a transfer order if it is in violation of a statutory provision or is actuated by Malafides, but violation of guidelines and instruction does not justify judicial interference. So even if it is assumed against me, I take the worst case against me, that there is a violation. That doesn't
Yes.
much of this. Rest of the things, Lordship, I have just, I don't want to over argue anything. Lordship. I don't want to have that.
Milord, just 1 minute. My learned friend referred to one judgment just now. Please come to para 7 of the judgment. Sorry.
Yeah. Mr. Chaudhary, just a minute.
Yes. ಇದು ಕಿ ಕೆತ್ತೋರೆ ನೀವಿ.
Yes.
Milord, just page 405 of the paper book, Milord.
405.
Yes, this is the judgment which my learned friend referred just now. Page 405, Milord. Para 7. This is the judgment which he referred just now. That the order of transfer has been made, para 7 at 405.
Who has relied upon this judgment?
Milord,
Who has relied upon this judgment?
just now my learned friend is.
No, no,
referred-
no.
In before the tribunal or
We,
you?
yes. Why we refer to the judgment, para 7, Milord?
Yes.
Third line of para 7. Respondents have therefore to satisfy the court that transfer was made for some administrative exigency. Merely repeating the phrase administrative exigency in the reply would not suffice when a specific charge of Malafide is made on certain facts which are borne out from the records and are not disputed by the respondents. The respondents have to satisfy the court as to the administrative exigency that necessitated the transfer. That's why I'm saying, my lord, that record part, it's only for this.
Order is there.
Much of. I'm really obliged for the patient care. I was over prepared, so I over argued.
No. Don't take it so seriously.
No. I'm taking it seriously that I'm taking it as a compliment word. I'm taking it as a compliment.
These transfer matters, there's
Yeah.
no need to go so deep into.
I know.
This is.
This is the affidavit by whom?
Yes, we have filed it, my lord.
Today?
Last time we took time, yes. Deep left.
Much obliged.
Item number 2.
अच्छा हाँ मैं तो ये पहले देख के सोचा है क्या है कॉन्ट्रैक्ट इसका तो 10 साल हो गया
Yes.
Not the impugn order passed by the London Tribunal, my lord, the tribunal has interfered with the transfer order. And my lord, the relevant portion of the, my lord, the findings by the London Tribunal is at, my lord, page 31. Starts from, my lord, 31, paragraph 8.
Yes,
May I read, my lord?
yes.
We observe that in the instant case, there has been violation of the comprehensive transfer policy of the railways, which is statutory in nature and which inter alia reads as follows. Normally, minimum tenure on a particular post at a time will be 2 years and maximum tenure will be 5 years. For sensitive post, maximum tenure will be 4 years. Minimum tenure will not be applicable for junior scale, senior scale officers of Group A. However, in administrative exigencies, relaxation may be granted by the cadre controlling authority. As can be seen from the above instance, applicant who had only recently joined in Guwahati from
We already
Dibrugarh.
issued notices. Yes, Mr. Who is
My
appealing for that?
My lord.
So, will admit this and hear this.
My lord, this matter, one small issue.
You have raised very pertinent question.
My lord, issue in,
Answer of
my lord-
this in violation of the policy, then we have to decide it.
my lord, here is a case where your lordship didn't go into the detailed facts. Issue is very simple and one. There was a policy, my lord. Earlier, this policy was framed pursuant to a direction passed by the Supreme Court. My lord, on the last occasion, if your lordship recalls, my lord, I considered that the Supreme Court judgment based on which this policy was framed was not in respect of a transfer. It was in respect of, I'm sorry, my lord, on that day, suddenly I was given the brief, I did not read it. That Supreme Court judgment was,
We'll hear it finally.
two issues are involved.
We-
There is a stay, my lord, operating, my lord.
We'll hear it finally.
My lord, even we want early disposal because the employee, my lord, is a Group A officer. He's not working
Whether you
since.
paid salary to him or not.
Yes, my lord, we have paid.
My lord,
Rather without working, my lord, he is getting salary. Rather, my lord,
He has not joined there.
no, my lord. Since
Yes,
2023, he is in Guwahati and without work, my lord, he has got the entire salary.
No, he has not joined at the.
No,
place.
no, no, my lord.
Till date.
Yes, my lord.
This-
He has not
uh,
joined, my lord, more than 1 year.
Well, I-
elapsed.
Not to interfere with this. sir.
I will find it.
And
Other,
this court has not even granted,
My lord, my
already stayed that order.
my lord, that I'll see. My
If
lord.
you have audacity not to join that, it's okay.
My lord, yes,
year
to
has
join.
Be happy with it.
My lord,
Then there is the need of court's order.
my lord, I didn't know that.
Even
Well,
though if
your
the
lord.
court order is not there, you.
I bowed on my lord. If there is no say, he has to join. Otherwise, my lord, case is in a very, very small campus, a very simple issue is involved, my
Whatever
lord.
it may be, we'll hear it.
My lordship, may I kindly
The
hear it
fact
at an early
is
date.
that you remain in Guwahati from last 8 years or in this region.
More than
My
10
lord,
years.
That's all.
No, my lord, I am here for 8 years, but then order, my lord, I acted as a whistleblower. Lordship, will kindly protect a person who acts as a whistleblower against a corruption. My lord, a particular mission, my lord, Lordship, will give me just 1 minute. My lord, I have clearly alleged Malafide, but since I did not make the person a party, my lord, I am not for a moment arguing malice in fact.
Whether you have joined or not.
Not join. No.
And I'm told he is not joined. He has to join.
And not willing to join?
My lord, he has to join, my lord.
Not willing to join?
No.
Outcome is this. We have already stated the order
Yes.
of the tribunal. This is the outcome.
My lord, my submission is he has to join. My lord, he has to join. I agree, my lord, he has to
Let
join.
First join and come. We'll hear.
Lordship, may kindly fix a date for disposal. My lord. I have got a very plain and simple case, my lord, based on a Supreme Court judgment. The order is absolutely arbitrary.
13. Come and join.
13.
Join and come.
My lord.
Put on 13. Interim order to continue. Is it limited? Put up on 13.
13th.
Supplementary list, item 49 to 51.
And just about the date, my lord, 13, Friday, my lord. 13,
What about the?
my lord. Before that, I'll ask him to join, my lord. Make sure.
My lord, before my senior starts, my lord, there is an order in this item number 50, which is arising out of a writ petition, order passed in writ petition 3395. And my lord, yesterday while going through the record, my lord, I have come that your lordship, my lord Justice Sham had passed an order to
In
take
writ
up the,
appeal or what?
no, in the writ petition, and writ appeal 60 arises out of that writ petition. So I leave it to your lordship, my lord. Writ petition, your lordship has passed an order, and the writ appeal 60 arises out of this writ petition. And other two writ petitions, all. My lord,
Put up this, these matters on 9.
Ninth. Oh, ninth. Ninth is fine.
One of.
Otherwise, my lord,
Otherwise,
I
there was
just,
some problem.
I
said
felt
because
it is my duty to
they
point it out.
proceeded
Otherwise-
for a contempt. We received a notice.
9th of the.
It's okay, no
Prior
problem.
to that 9th.
My lord, the problem is that when I was sitting behind the back, I am worried about thunderstorm and lightning. Thunderstorm and lightning, whenever there is a rain, then there is a lot of problem now in Guwahati.
So now it's,
No, it is warning is given. We're full. Our road is full of, it's underwater.
Rains are going on.
No, it will not go on. It is warning is given, my lord.
Where is the warning?
Warning, thunderstorm, my lord.
Lightning.
Lightning.
It's a,
There is a problem,
it's a,
but, what did we do, sir? We are tackling this, we are trying to tackle this situation.
it's a.
Mr. Das, we are seeing stars inside. We don't see the lightning outside.
No, my lord.
Not as
Whenever
fortunate as
we
you.
are always comfortable, people.
My lord, sorry to interrupt, my lord. I have received a lot of suggestions which I'll be coming up on 13th. my lord. Lot many
But,
people,
Mr. Chaudhary,
people with lot of interest have taken the matter very seriously, and all the technical persons, my lord, they have come up. In fact, a WhatsApp group has been formed where I have also been added. Now all of them are putting in. All are
You had
well-to-do people.
Mr. Das also.
Yes, yes.
Yeah.
I'll just give him, my lord. He need not worry. In any case, tomorrow is a holiday.
And one problem is there in all the roads. I don't know how it is, parking from both the sides. Even there are repeated orders from the traffic side, parking from both the sides. I know one matter was dealt and I was here, both the side parking. I don't know how the police comes and for a moment, 1 hour, they will say, yes, they'll blow whistles and will go. After that, again it starts.
That's right. That's
Not my area. My area is hopeless. Other areas also same position is there. Same.
In fact, this is the position in every city in whole of the country.
Yes.
And it's these on footpaths, the sellers are there, every vendors.
Yes.
If you touch them, then they will go on strike, and I don't know what, can't even explain.
Yes.
It's the whole thing.
I'm the pure blessing.
Item 52.
Yes.
May please. My lord, here the impugned judgment, my lord, at page 195, dated 1/8/24, is partly challenged, my lord. But in fact, this is a case under the Provincialization Act of 2017, my lord. Now, what has happened, my lord? In fact, under, my lord, the provisions of the Act, more particularly Section 3, subsection 1, clause 11, my lord, one teacher from each subject, my lord, science and mathematics, language, my lord, and social studies are required to be provincialized.
No, you just, where is that order of 26th of June 2023?
My lord, that order your lordship will find, it starts from page 38, my lord. 38.
Yes.
Now, my lord, before
High Court's order dated so and so proposal for provincialization of services submitted by D.O. Dugri with the recommendation of so and so. Yes. You are
Abul Hassan, my lord.
You are Abul Hassan or?
Right. I'm Abul Hassan, my lord.
Abul Hassan, yes.
My lord, if I briefly state the facts, very concisely and precisely, my lord, what led to, my lord, passing of the impugned judgment by the honorable single judge. My lord, in terms of the provisions of the Act, my lord, one teacher from each subject is required to be provincialized. By, my lord, the earlier provincialization, which was subsequently cancelled, one teacher from maths and science and two teachers from language stream was provincialized.
Fine.
That is respondent 1 and respondent 10. Thereby, my lord, depriving me. I belong to social studies.
So you filed this petition?
I filed earlier round of it. I came to honor.
2021 petition.
Absolutely, my lord.
And in that, the court has ordered that again decide the issue regarding privatization of the petitioner and the other respondent.
In fact, my lord, the honorable court directed me to submit the application. And essentially, honorable court says that the respondent 1 and 10, they will also approach their inter se seniority is required to be determined, my lord.
Para number 10, page 35.
My lord.
of this paper book. Na. Accordingly, the writ petition is disposed of by permitting the petitioner to submit his representation
Yes.
before the so-and-so together with the certified copy of the order
Yes,
with the enclosure so-and-so. Upon receipt of the respondent shall dispose of the representation 2 months and so-and-so. It would also be
yes,
open for the
Correct,
respondent to approach the authority concerned. So the learned single judge is given a direction to again
Yes.
decide the matter regarding provincialization of the petitioner and other respondents.
yes,
And
Correct.
wide order dated 26th of June,
yes, my lord.
this was decided.
Yes, in fact, the director, my lord, found that I am entitled to provincialization in social studies stream.
Fine.
And also, my lord, the director found that the respondent 10 herein, he is entitled to be provincialized under the, my lord, language stream. Thereby, my lord, the writ petitioner respondent one was aggrieved. And
Okay.
then he filed a writ petition, my lord.
In view of the now we come to paragraph number 43. Page number 43, last operative portion of this order dated 26 June 2020.
My lord, page 43. 43, my lord. Yes.
In view of the above facts and material on record.
Absolutely. By this order, I have been provincial. Yes. In view of the above facts and materials on record, it is seen that the petitioner Abul Hussain was appointed additional assistant teacher of Keshar Vita and MEM so-and-so and wide order dated 16/6/2017. It has been stated that he is liable to get all benefits of his service as assistant teacher of the Keshar Vita MEM and may be considered for provincialization of services as per Act 2017. As also the name of the petitioner was recommended by the DSC Dhubri for Provincialization of Service Act 2017 as social science teacher against Keshar Vita MEM White DEO Dhubri letter dated 11/1/18. The respondent for Abul Akher was appointed on 31/12/2002. So he is junior language teacher among the 2 language teachers of Keshar Vita MEM whose service has been provincialized as tutor on 4/2/2021. The other being Mohammad Soiful Haq, who was appointed in the year 1993. Therefore, the claim of the petitioner, Abul Hussain, that is the appellant, my lord, for provincialization of services against Keshar Vita MEM is considered, though the name of the petitioner is found to disappear the DICE verification data up to year 2013-14 against Keshar Vita MEM, and the provincialization of service order while issued notification dated 4/2/21 in respect of Abdul Akher is hereby cancelled.
This was the order. Your services were provincialized and Abdul Akhar services were provincialization was cancelled.
Cancelled, my lord.
Against this order, who has filed the petition?
That my lord Abdul Akher filed the writ petition, my lord.
Then what happened?
Yes. Now, while filing the writ petition, my lord,
You were not party before the learned single judge?
I was a party, my lord.
You were a-
I was arrayed as respondent 10 therein, my lord.
Abul Hassan,
Abul Hussain, my lord.
fine.
And my lord, the respondent Saiful Haq, my lord. He was the contestant, my lord. In respect of language, he was implemented as respondent 9.
Fine.
Now, my lord, my submission before the honorable single judge was that in terms of the, my lord, act, the claim is between, my lord, the respondent 1 and respondent 10 hearing, because they belong to the same stream.
Language state.
Language stream, my lord. And therefore, my lord, the writ petitioner did not have any claim against me. Even if I,
Wrongly implicated you as a party. Okay.
absolutely correct, my submission was, I'm a misjoinder, so please strike off my name from, my lord, the cause title, my lord.
Fine.
But this submission was, my lord, not considered by the honorable single judge. Rather, my lord, what the honorable single judge did, my lord, on the basis of the admitted facts, my lord, the provincialization of the appellant was maintained.
Where is that?
Yes, absolutely correct. I come to the impugned, my lord, judgment, which starts from, my lord, page 195. I take your lordships to the operative part. If your lordship comes to,
Provincial is already affected in case of respondent and now directed to be affected in case of respondent number 10. Shall however be subject to the decision of the jurisdictional election, the proceedings that would be instituted by the petitioner in terms of hearing. So, what's wrong?
yes, my lord, the honorable single judge upheld my provincialization, my lord. At the same time,
Where is that appeal?
yes, yes,
Where is that appeal?
yes, yes, my lord.
Provincialization is already affected in the, and did be affected in case of shall however subject to the, where is that question?
No, your lordship will come to para, my lord, 48, page 207. Page 40, page 207, para 48.
48.
Yes, my lord. As regards the respondent number 10, that is the appellant herein, it is already concluded herein above that he being the sole social studies teacher in the school and there being no other claimant for the said post, he would be eligible for having his services provincialized against the existing post of social studies teacher. Now your lordship will read this along with para 55 at page 208.
Yes.
Insofar as the petitioner in WBC 4881, that is the appellant, my lord, he filed his writ petition for my lord, asking for the consequential order. This court in WPC 4564/23, having not interfered with the order 26/6/23 and by reckoning the conclusions as reached by the Director of Elementary Education that the services of the petitioner is entitled to be so provincialized, this court hereby directs that the Director of Elementary Education Assam shall issue consequential order towards provincializing the services of the petitioner herein. Petitioner means, my lord, petitioner in 4881. That is me, my lord. With effect from 1/1/21, as was so done in the case of the provincialization of the services of the other servicing teachers of the said school with all consequential benefits of pay, seniority, etc.
That's correct. It's correct. एक तो अगर आदमी को डिसाइड करना होगा क्या होगा
Who is appealing for the private respondent here?
My lord, none, my lord. Today.
Okay, issue notice. You're appealing for?
I'm in elementary.
My lord, can it be this way, my lord? In fact, your lordship is aware, my lord, even if, my lord, supposing, my lord, this writ appeal is allowed, even then, my lord, the private respondent is not an affected party.
We understand, sir.
Correct,
That's why
my lord.
only we just want to hear the private respondent. Do you have any grievance against your provincialization? If he is not having any grievance against your provincialization and he is seeking his conferment of his rights about the like provincialization and others, we will clarify it.
My lord.
We'll clarify it. What's the problem in that? Issue notice. Mr. So accept notice. Yes, Mr. Deputation.
I am from number 2, 4, 6,
And what about
7,
others?
I'm appealing for finance, respondent number 3.
How many respondents are there?
Total 10, my lord.
10.
Yes.
My lord, I need to take steps by registered on 1 and 10, my lord. Other are official respondents.
9
my lord.
also, 9 also.
9.
1 and 9.
1, 9 and 10.
1, 9 and 10.
So register.
Who is the one?
One is the, my lord, writ petitioner, my lord.
State of Assam representative secretary government. Writ appeal में तो अच्छा. Okay.
ये रिपीटिशन का है पार्ट ये है अभी ये है 1 8 सारे 9 and 10 9 and 9 बनाया उसके बाद
Notice. Mr. So and so is appearing on behalf of the
decided body 2 to 8
official on behalf of the officers of the government who are respondent number 2 to 8 whatever the names you just, let notice be issued to the respondent number 1, 9 and 10, returnable on 23rd of September.
My lord.
That's the.
My lord. My lord, your lordship, my lord, my one prayer is,
Yeah.
the honorable single judge has asked the debt petitioner to approach the educational tribunal and also to implead me, my lord. There is a direction in,
Where is that, sir?
there is a direction in para 54, my lord.
Para 54.
Absolutely, my lord. Expressly provided.
54.
Yes, my lord. The petitioner in WBC so-and-so, page 2.
Issued so-and-so establishing claim of providence with the petitioner in the event issued shall include.
Respondent 9 and 10. I am 10, my lord, in the writ petition.
Proceeding initiated.
This may be stayed, my lord. In para 57, my lord. And your lordship will see, my lord, in para 57.
Next returnable date. The educational tribunal. Till interim date, if the respondent, if the respondent, who is the respondent, he is required to approach the tribunal.
My lord, respondent 1, Abul
If the
Akhir.
respondent number 1 approaches the educational tribunal pursuant to the direction given by the learned single judge in the impugned order, the educational tribunal shall not proceed with the, shall not proceed in the proceedings filed by the respondent number 1
Against the present appellant, my lord.
till next date.
Against me, my lord.
If you are going to stay the order, who is going to affect by this?
My lord, against me, he will not proceed, my lord. Otherwise, my lord, he can proceed against the respondent 10, my lord. So fuel hog.
In the meantime, effect and operation of the order dated so and so impugned order shall remain stay till next.
My lord, in fact, there is a positive direction for release of my salary.
No, Mr. Talukdar, next date.
My lord, what I pray, my lord, there is a part also positive direction. If the entire, my lord, order is stayed, what you will kindly see, I am affected, my lord. There is a positive direction for, my lord, release of salary, etc. This part may be stayed, my lord, with regard to the, my lord, proceedings before the tribunal. Other part, your lordship may not stay, my lord. I am challenging part of the judgment, my lord. That part may not be challenged, my lord, stayed, my lord.
In the meantime, in case the respondent number 1 herein initiate any proceedings before the educational tribunal pursuant to the direction given by the learned single judge in the impugned order, the educational tribunal shall not proceed. Shall not proceed till next day.
Deeply obliged, my lord.
Daily list for hearing item 3 to 7.
Wait, please allow. Well, Lord, now in the context of the affidavit filed by the state, Lordship will have to take a call in the matter, my Lord. My Lord,
Last time we remember that
yes.
he granted you some.
In fact, my Lord, we could lay our hand to one judgment of this honorable court, which has been upheld by the Supreme Court, my Lord. And in fact, the author of the judgment was my Lord Justice Shuman Shah. That is, my Lord, Rishikesh Das versus APSC, 2019 4 GLR 170. Say na? Otherwise, on merit, my lord, the learned single judge did not interfere with the issue on the ground that there is no enabling provision in the form of the rules. Because, my lord, there were serious infirmities in the answer keys. Paise?
Mr. Chaudhary, do you have the Supreme Court judgment?
Yes, yes, yes. The issue has been kept open, but my lord, the Supreme Court has declined to interfere. First, if your lordship would kindly take this Rishikesh Das para 4, my lord. Sorry, paragraph 10, my lord.
Paragraph 10 of the judgment?
Yes, my lord.
Yes.
Mr. Datta has urged that unlike in the pre-amended rule, the Assam Public Service Commission Procedure and Conduct of Business Rule 2010 does not contain any provision for commission to reassess the answer vote. According to Mr. Datta, absence of such a provision in the rules, coupled with the embargo created by Rule 74 of the rules, prohibiting the commission from entertaining any request for re-examination of the answer script, has created an anomalous situation inasmuch as candidates such as the petitioner herein have been left remediless. Mr. Datta submits that once it has been found that petitioner has been wrongfully denied 10.15 marks by the examiner, costing him job of the inspector of taxes, he cannot be left remediless merely because rules of 2010 does not contain any provision permitting commission to redress the grievance. Relying on the maxim ubi jus ibi remedium and the rule of equity, learned senior counsel submits that this court would have ample power to remedy the situation and issue appropriate writ or direction, directing the respondents to give credit to the petitioner for the marks legitimately scored by him in the general studies paper and render justice in this case. In support of the aforesaid argument, Mr. Datta has relied upon the following decisions. Then my lord, lordship may kindly skip those judgments. Please come to my lord paragraph 14 at page 219. From the decisions referred to herein above, it is thus apparent that jurisdiction of the High Court under Article 226 of the Constitution is expansive in a case of this nature, where answer scripts needs to be reevaluated or should it be referred for expert opinion would be a matter of discretion of the court to be exercised depending upon the facts and circumstances of each case. Such direction, however, is required to be exercised with much circumspection and in a manner consistent with the concept of justice, equity, and good conscience. The Roman jurisprudential maxim of ubi jus ibi remedium means that where law provides a right, there has to be a remedy. In other words, where there is a right, there is a remedy. Referring to the rule of ubi jus ibi remedium, the Supreme Court has observed in the case of so-and-so, relied upon by Mr. Datta, that Article 226 grants extraordinary remedy, which is essentially discretionary, although founded on legal injury, and it was perfectly open for the court to exercise this flexible power as public interest would dictate on or equity projects. So, my lord, this was the principle basically. Then eventually at para 18, my lord, in the case in hand, the respondent number 1 commission had refused to grant any relief to the petitioner, taking the plea that Rule 76 of the rule of 2010 did not permit re-examination of the answer script. As such, controversial answers were referred for re-evaluation to subject experts who have opined that petitioner was entitled to 10.5 more marks for the answer given by him in the general studies paper. The subject experts are very knowledgeable persons who are teaching in the reputed university, and their opinion has also been explained by putting up notes where necessary. Respondents have not contested the opinion of the academic experts. Situated thus, court finds no good ground to reject the opinion of the subject expert in the matter. So in this case, of course, my lord, the matter was referred to some subject expert, and subject expert opined that in the given facts of this case, he was entitled to 10.5 more marks, and which was considered. Now, in our case, my lord, and before the learned single judge, this issue did crop up, that the matter should be referred to the expert. But eventually it was not done. My lord, the judgment was kept, I think, for reserve for more than almost 2 years. Thereafter, it was given, my lord. Now, in my humble submission, my lord, we can show how the answers were demonstrably wrong. And that is why perhaps, my lord, APSC have clearly taken a stand in respect of both these batch of candidates, one batch of 4 who were, my lord, permitted to sit. And of course, we, on the strength of the order of this honorable court, we appeared in the mains, we appeared in the interview and came out successful. Now, my lord, coming to the stand taken by the state, my lord, it is not my submission either that state cannot take that stand. Perhaps, my lord, state has taken that stand. The question is whether lordships would give due deference to the stand of the state government in the scheme of the rules, my lord. If your lordship permits me, I can just place the Assam Civil Service rules, my lord. My lord, in fact, we have filed a reply affidavit where I have explained the position at paragraph 3, my lord.
456.
If your lordship kindly comes to page 456, then I'll refer to the rules, my lord.
456.
456.
In which petition?
My lord, it's in item number 4.
Shalini Khan.
Mr. Chaudhary, would you please recapitulate the background facts?
Yes.
In a
Yes,
very
yes, certainly.
brief manner.
My lord, what had happened on 13/3/2019, my lord, preliminary examination result was declared. Where, my lord, 60,275 candidates appeared, out of which 3,361 was declared to have qualified in the preliminary examination. Then, my lord, normally what the APSC does, my lord, before declaring the result, they upload the answer key, so that in case of any incongruity or infirmity, my lord, so it can be taken note of. In this case, what the APSC did, first they declared the result of preliminary, then they published the answer key. Then once, my lord, the answer key was published, lot of hue and cry was raised in all the newspapers of the state, in news channels. This matter was reported. Then what they did, my lord, in fact, the appellant petitioners are also filed representation. Then, my lord, suo moto APSC on 34/19, where 34/19, my lord, they suo moto took cognizance of the matter and mistakes in the answer key. And, my lord, they qualified 406 more candidates.
Revisited the results.
Revisited the result. 34/2019.
Now, just.
Yes.
The appellants, the appellants are the persons whose names were figured in the first list or revised list?
No, my lord. No. The 2 appellants before your lordships in one series and 4 appellants in another series, our names did not appear. We say,
In both the lists.
yes, our names did not appear, my lord. What had happened? But when we demonstrated before the honorable court that these are the answers which we have answered, and these are the domain expert who have said what is the right answer, on the basis of that, my lord, we are permitted to sit in the mains examination.
177 to 42, 177.
My lord, if your lordships would kindly have a look at page 177.
Just a minute, just a minute.
Facts to media ভালো করে। 77 क्यों खोला? 18 है? No, they do that. One second. 290 and 315. 290, the APS is 10 plus. 290.
You mean to say that on 13/3/2019?
Yes.
When the examination result was declared, your name was not.
Not there.
All six.
No, two of us.
Two of us.
Yes.
Who are those two persons?
My lord, item number 4 and
Name.
name Shalini Khan and Girbani Deka. Shalini Khan and Girbani Deka.
And Girvani. Okay. And in that revised list.
Yes.
Revised result on 30th of April 2019.
No.
Again, your names were not there.
Not there.
Okay. This is the one set of appellants.
Yes.
And another set of appellants.
In the another set of appellants, my lord, they were shown to have qualified
In
the
original reason.
yes, yes.
On
Then APSC came out with a notification that there were a batch of 98 who ought not to have cleared, but they were shown to have been cleared.
So yeah, on 13/3/2019, when the result was declared, their name was there.
Yes.
But on 30th of April 2019, when the new list or the revised result was declared, their name was not there.
No, it was there.
It was there.
It was there. Subsequently, my lord, they filed an affidavit where they have taken this stand that the list contains 98 candidates, including these 4 who ought not to have cleared, but they were shown to have been cleared.
This discrepancy they have shown.
Yes.
Okay, this 98 out of these 400 and something odd persons, 98 persons are not supposed to be in the revised list, but their names have wrongly been.
Yes. Not 400, entire batch, my lord. That will make 3769. Initially, it was 3361, then 408, so it is 3769.
When the second list was published, 408 were included and that 98 other people who were there in the first list were excluded.
My lord, we have given a list of date, whether it is on record, someone given. There, my lord, we have given out everything very clearly.
We also like to chart. I think that
My lord, there is a list of date in item number 3 and 4.
Now, what the learned single judge has done, in between, you are allowed to appear in the mains examinations.
Then my lord, then we qualify in the mains.
Yeah.
Then I was allowed to participate in the viva voce.
Right.
However, my lord, our results were withheld because of the interim order.
Post were stayed.
Post were set. Even date, my lord, the six poster kept, vacant.
Fine.
That is the position.
Now, what the learned single judge.
Yes. My lord, learned single judge basically wants to say that since there is no provision for re-evaluation, relaxation, therefore our prayer cannot be accepted.
Relaxation of.
And
Relaxation of what?
relaxation of marks, my lord. That we did not pass the preliminary.
APSC themselves say it's a screening process.
And APSC stand is, my lord, it's a screening process.
The marks
So
are.
it can be avoided.
Yes. Your lordship, would kindly permit me to place one page, my lord. That's where the stand of the APSC is clearly indicated. If your lordship would kindly come to page 290.
Any observation by the learned single judge in relation to the revised result?
Not directly. Learned single judge has eventually, my lord, held that we do not have an enforceable right because we were not selected. Sorry, we did not come out successfully in the preliminary examination. That is the basic finding. But learned single judge has not made any attempt to find out the other plea which were raised. That since the rule does not provide anything, demonstrably the answers are wrong, is the court, my lord, powerless. That aspect learned single judge has not. And most importantly, my lord, the matter was kept pending for 22 months. Thereafter, my lord, the judgment was rendered. End of the day, we stand in the same city. আমি বরঞ্চ তোমালোকৰ ক্ষেত্ৰত বেছি মৰম কৰিব বেছি আমাৰ অলপ কম কৰিব মই অলপ বেছিকে মৰম কৰিছো এই আমাৰ আগৰ চিফ জাষ্টিছে কিন্তু অলপ বেলেগ আছিল
These,
Yes.
all those 98 persons who were excluded,
Yes.
they have not approached the court.
No, no, earlier they did not. Now they are before the court, my lord.
And they were never notified, my lords. They were notified at the stage when they had already cleared the mains, my lords, and they had appeared for the viva voce. Now, what had happened, my lords, initially.
What happened to those 98 persons?
Initially, 3361 candidates, just a minute, initially 3361 candidates were selected by way of the first answer key, my lord.
13/3/2019.
Yes,
Yes.
3361. Thereafter, my lord, when there was a suo motu revision of the answer key, another 408 candidates were included.
3769.
Yes, yes.
Total.
And when the 408 candidates were included, pursuant to the revised answer key, 98 candidates were ought to have been left out. But the APSC did not declare their names. And APSC said without prejudice to those 98, 408 candidates would be included. So those 98 candidates, which my client Saswati and my learned friend's client Tarmalas, they were never notified that they were part of those 98. It was only at this stage when they had already qualified in the viva voce,
Fine.
the honorable single judge had issued an order that who were those 98 persons, you identify them, and if anyone has cleared viva voce, you stay their appointments also. So that is the Malak's position. So at
Here
that
in
point
this-
of time, we filed an
This,
impediment.
this,
Yes,
and so far as regarding that your exclusion
Malak.
from the original, whatever the pass out candidates,
Yes.
that you have not challenged.
We were never notified. We didn't even know how, Malak, because it was at this stage after, it was because my learned senior
But
friend.
after knowing this trend of the.
Yes, we filed an impediment. We filed an impediment in Shalini's case, Malak.
These appeals.
Yes, yes, in Shalini's case,
Single judge.
before the single judge, before the
Okay.
single judge.
And the single judge allowed your impediment.
Impediment was allowed, but by way of a common judgment, our impediment and the writ petition were dismissed, Malak.
साथ ही लिया है मेन रिट
এইটো বঢ়াই ল'লে অলপ bias হ'ব।
That's what, so out of those 98, only 6 have assailed the decision.
Because, Malak, out of those 98 candidates, Malak,
Only 4.
only 4 because they passed, Malak.
Others
Out of
did
those
not.
98, they did not qualify in the, either in the mains or in the viva voce, Malak. We qualified, the 4 candidates qualified in the viva voce. And at that point of time, we were notified that we were part of those 98 who were not supposed to be included in the list, but which the APSC has said would be not.
You moved an application for your impediment in one of the writ petition without challenging that action of the APSC of excluding you.
Yes.
Or declaring that these 98% were
That-
not
that-
ought to
that-
have passed,
Yes.
but they have wrongly been passed. You have not challenged that
Because,
decision.
we could not have challenged that because the
Why?
names were not disclosed.
Ultimately, when before the learned single judge, your names were disclosed, then you should have challenged that action of the APSC.
For challenging because APSC always held that they stood by their ground to include us. Lordship, what happened initially was there was a list notified. Notifying everybody, in which we were included. After that, there were complaints, they swore to reevaluate. When they reevaluated, they found that from the first list, 98 are not eligible. They did not meet the cutoff on the basis of a reevaluated answer keys. And 406 comes in.
408.
408 comes in, they should ought to have been qualified. What does the APSC do at that point of time? APSC decides that without prejudice to the 98 being included in the first list, which means the first list notifying us as qualified to appear for the written test is not disturbed, we will also include 408. So everybody is in the pool.
Those names are not.
These 98 was never intimated at any point of time.
At what time?
At the time when we were selected, the list selection We were intimated by the officials that were selected, but there was a note subject to order. There was an interim order of the court that you will not disclose the results of those
Won't appoint them.
by an order of the court. Which is why we realized that there's an order of the court that notwithstanding our place in the select list and having successfully selected, there's a matter pending, and at that last stage, we get to know. So in January 21, we come to this
Challenge
court.
that action of the APSC that they excluded you 98% so out of only 6%.
They did not exclude me.
That's not a case. Just 1 minute. But it was. So by the showing of the APSC, went into the fields taken. So according to APSC, they were allowed to take in the main testimony as against the past right here only. Then they went up to the state of Bible. Then they were found selected candidate. The result declared. I thought prophecy. But they were allowed by APSC to meet the right. And now they if you see the screening, but because that was rather media. The complaint दूसरा तो इससे higher mark no question. But one is there to screen. Only to is there till
in respect of each candidate. मेरे को भी मैं 68 है पास क्वेश्चन में out of 98 68 है पास हां सॉरी नो साइड है
177.
Miss Goswami, where is that document which shows that your clients have cleared the preliminary examination? The first document. Where is it?
Page 177 question, right? Dr. Judicial.
My lord, 177. Page 177, my lord, in the paper book.
177 of
The paper book, my lord.
Which paper?
Salini Khan, Salini Khan.
My lord.
The Salini Khan Deoks.
Yes. 30th of April, 2019.
The commission without prejudice.
Page 177, my lord.
177, yes.
Yes. The commission on receipt of the information complain on accuracy of some of the answer key. আছে, আছে। One?
We were notified and qualified on 13/3/2019.
Yeah. 13/3/2019, you were declared as qualified.
Now what the learned senior is reading is after the evaluation, they came back and included 408 again.
Without prejudice.
That is without prejudice, not should be.
That is 177.
The commission on receipt of information.
Please come to this sub-para, my lord. The commission therefore, without prejudice to the results, earlier published white letter dated 13th of March 2019, decided to consider the said candidates qualified for appearing in CC main examination 2018. Roll number of the qualified candidates are given below in serial order. Commission will not be responsible so and so. Result may also be downloaded. So without prejudice, my lord.
What if, the commission means to say that earlier also the result was there 13th of May, this March 2019. And these other persons are also included in that list.
Delete me.
Yeah. Then when this fact was revealed that.
Only when, my lord.
Out of these 400 or whatever the 3, 7, 6, 9 candidates, 98 persons
When we
who were, who ought to have been kept out of this list, but wrongly listed. When this fact came to the knowledge of the.
My lord, that issue was raised by the learned single judge.
You name the person.
Yes. That identified the person out of the batch of 1998 who have cleared mains and, interview.
98 itself was.
My lord, if your lordship will kindly come to page 290, that will clarify the position. 290, that is the stand of the APSC, my lord,
Yes.
where they have factually also given the background.
Yes.
290. Minutes of the meeting of the commission held on 25/1/2021.
Yes.
It was pointed out that the Honorable Guwahati High Court white order dated 22/12/20 passed in IN number so and so was pleased to direct commission to declare the final results of CC 2018 and withheld results of 6 candidates. These are the 6 candidates. Further, the Honorable High Court white order dated 18/1/2021 passed in WPC so and so directed commission to clarify its stand with regard to the aforesaid 6 candidates by filing fresh affidavit in this regard on or before 28/1/2021. The commission discussed the matter and observed that out of 98 candidates, 68 appeared in CC mains exam, and out of these 68, 4 candidates, Saswati Das, Vidisha Boro, Manish Borua, and Anupam Deka, could make it to the final select list, and in persons of the order dated 22/12/20 of the Honorable High Court, withheld their recommendation to the government. Commission is now of the considered opinion that as CC preliminary examination is a screening test and they could not clear it by a whisker, and these 4 candidates by virtue of their own mark could successfully clear the CC main examination and viva voce, both of whose marks are taken into consideration in the final selection. Hence, commission fully stood by their recommendation as justified. So as regards the other 2, my lord, next para. That with regard to the petitioners in 3341, that is Salini Khan and Girbani Deka, the commission opined that Honorable High Court in interim order allowed both the petitioners of WPC number so and so to appear in CC main exam 2018, and they cleared both CC mains and viva voce by securing position in the final merit select list by virtue of their own merit. As such, the commission in respect of these 2 petitioners leave the matter to be decided by the Honorable High Court, and hence commission has nothing to object to any decision to be taken by the High Court by considering the fact that both the writ petitions have qualified for a recommendation by the commission on assessment of their respective merit NCC main exam and
The-
interview.
What was the occasion for the learned single judge to find out that out of these 400 additional candidates, 400 odd additional candidates, 98 persons or from the whole list of the eligible candidates, 98 persons were not ought to have been included in the list.
No,
but
what had
wrongly
happened, my lord?
included. Where was
The occasion was in the affidavit filed by the APSC.
Okay.
For the first time, this fact was disclosed that it also contains a list of 98 candidates who ought not to have cleared, but they were shown to have cleared. It is in that context the learned single judge asked the APSC. Then out of that
That
98,
was the case of the APSC, APSC.
yes. Out of that 98, whether anybody is selected. When the answer came, yes, 4 of them were selected, then there was an order for identification of the 4. Then, my lord, they got to know when in their select list, their names were shown as withheld. Then they made an application seeking impleadment. Yes, you know. अभी एज 10 to reach and to reach it. A 2 350 not. 315. बाद में कह रहे
APSC.
And qualifying in nature. Still get some copy of the app or did you hang on? Na liha sih kan di mana? Duta dia copy dari di print. Angke dasar nih ya.
রাজীব বরকন দিব বুঝছা আমাকে নাকি চ্যালেঞ্জ না চ্যালেঞ্জ করুন দিতে কোম্পানি দেখতে কোম্পানি তো প্রাইস
Mr. Chaudhary,
Milord.
we just want to clarify ourselves or understand the position. We'd like to go through the this SB record, order sheets, etc.,
Milord.
and the pleadings also.
Milord.
Because to come to a conclusion without going into all
Milord,
the
what
facts
I'll
and
do,
without
Milord,
considering
I'll
all the
prepare
facts,
a-
it would
I'll
be
pre-
difficult
prepare
for
a
us to
concise
come
list
to a
of date.
conclusion.
I'll prepare a concise list of date, starting from single judges, Milord.
That, yes,
Yes.
the dates,
Because those
Because-
dates will also be relevant here.
because there are many on so and so date, the court has given this
And
direction.
especially when this issue cropped up.
Yes, yes, yes.
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 We'll do that.
Because what I feel is that the fact remains that neither these two appellants nor these four other appellants, as per the APSC, have cleared the prelims
And
examination.
Milord, preliminary is only qualifying, Milord. This mark is not added. It's screening.
But
Yes.
I have not cleared the this preliminary examination. Now, what relief they are entitled to, and so for that some clarity will.
Milord,
So you give us a brief
Milord, we'll do that.
and we'll list
Lordship will have it-
whenever this next bench is available.
Yes.
Because in the next few weeks, I may not be able, I'm not sure that whether this bench would be available.
Whenever this bench is available next, Milord. Yes.
List of data.
Milord will come out with a concise list of dates,
Yes, yes, yes.
starting from that cause of action.
Yes,
Yes.
cause of action, yes,
Yes.
yes. yes.
May I be permitted, my lord? My lord,
Yes,
may I be permitted to mention item number 15 to 20, my lord? I am
yes,
appearing in this matter, but unfortunately, I won't be able to make myself available in the second half due to the medical emergency of my wife.
okay.
15 to 20, my lord.
20, 15 to 20.
Who is for the other side?
I am in 15 and 16, my lord.
Yes, Mr. Counsel, on account of medical
Yes,
emergency of his wife, he is not be able to attend.
My lord, I'm so devastated.
Yeah,
I'm so devastated.
Why are you devastated?
Because I was expecting we'll have a hearing and then the case will
no,
be
that's
closed.
right, it's
It's an
daily
open and
business.
shut case, actually.
It's not a case of devastation. Yes.
I was ready for the hearing.
But what date? Yes, Mr. You are coming from outside.
Yes, lordship.
So which date do you want?
As early as possible, lordship.
Hmm?
As early as possible.
First date.
The
As
earliest
early as
date.
possible.
I
As
cannot.
early as possible.
On 24th, if possible, Lordship.
24th, okay, 24th.
Yes, lordship.
24th.
24.
Yes, lordship.
I'm deeply obliged.
Obliged, Lordship.
Oh, my God.
Yes, please.
The previous ones.
Taking a long time.
Yes.
For hearing, item 22.
May it please your lordship. This matter relates to absorption in the health service in Mizoram, lordship. The petitioner before this honorable, the appellant before this honorable court, he came to deputation in the year 2011 from a central agency that is called ESIC under the Employees State Insurance Corporation of the central government, lordship. And he was brought to the health department of Mizoram in grade 1 post at the request of the Mizoram government, lordship. That document page 65.
Just a minute, sir. How many respondents are there?
Oh, there are private respondents. I think Mizoram government is sailing with us because at their instance only we came and we were absorbed. So we'll be on the same side, but the other side is not present.
Mizoram government is already Public Service Commission.
Yes, they are all on same page, lordship.
And who is for the private respondent?
KN Chaudhary. So let it be adjourned for today then in that case, if they are not.
If he is not here, then, so otherwise we'll start hearing, no problem, but if he is not here, then he is available.
Let it be taken up day after tomorrow in that case, lordship. Otherwise, I am prepared with the case, lordship.
No doubt, but if Mr. Chaudhary is here, we can hear it, no problem at all. We have time, enough time.
Amatu?
Fast forward for the time being.
Yes,
Let
lordship.
us see.
There is another matter, lordship, which I think that will be the next matter. Oh, there is a series in between. Ames matter is also.
Item 28 to 45.
Lordship, I am in item number 28.
All these matters are connected matters.
Lordship,
28 to 25 are the connected matters.
connected matters, Lordship.
45.
But Lordship, 28, my matter is, Lordship, it relates to the Dimasa district, which is under 6 schedule area, Lordship. And their service condition was something different from the others appellants, Lordship.
So only one case is different.
Yeah, only one case, 28, Lordship.
Okay. And what about the others? Who is appearing for the other persons? Yes, other appellants. 28, what they are saying, it's a different. And other appellants.
For the other appellants, my lord, the learned council yesterday, they gave me a call, my lord, that they will be seeking an adjournment of the matter.
Who is for the, who was the point?
My lord, they told me that, my lord, they are led by senior counsel KN Chaudhary. He is probably having some difficulty today.
At least some mention should be there.
Oh, yes, my lord. But otherwise, my lord, these matters are interconnected. Issue is whether, my lord, the petitioners, for that matter, my lord, the appellants herein will be covered by the new pension scheme or they will be covered by the 1969 rules.
The London single judge has bifurcated 4 categories of persons.
My lord, there are categories of, my lord, petitioners involved, considering their nature of services, my lord. Few categories has been called out by the honorable single judge. And to that extent, my lord, one category was called out with regard to, my lord, appointment of teachers under the OBB scheme. To that extent, my lord, this honorable court by an order dated, my lord, 27/6/2024 had, my lord, bifurcated several appeals and, my lord, relegated the matter to the government for consideration.
Separated.
There was an order passed by this honorable court, my lord, dated 26/7/2024, where, my lord, several writ appeals, my lord, were decided. My lord, it was decided on the ground, my lord, that there is a talk going on between the, my lord, petitioners association and the government for some consideration whether they would be given a leeway, my lord, to come within the ambit of the old pension scheme.
That's a R Devil and I also restricted and so and so. Appearing for the, and that these writ appeals are not connected. And the other writ appeals listed today are disposed of by this honorable that prayer has been made a secretary appeal from the connected chart. Those earlier some petitions were decided and
Yes, my lord, by an order dated, my lord, 26/7/2024. 18 writ appeals have been, my lord, disposed of by this honorable court.
what to do?
Lordship, this matter may be may be separated from the other matters, Lordship.
Madam, separated will here separate करने से what is the purpose of separating will? Here separately all these persons. Why to?
Because Lordship, as per the order, it was directed that they will be given the new pension, under the new pension scheme, these petitioners will come. But the fact is that Lordship, in the Dimahasa district, new pension scheme was made applicable only in 2021. And my appellants have been, Lordship, appellants retired from service during the period 2016 to 2020. So they do not, they will not come under the new pension scheme. And otherwise, Lordship, in the initial, their initial appointments were during the period 1989 to 1990 by the council, Lordship. And, education being a transport subject, Lordship, in the North Kasai Hills Autonomous Council, and they have the authority to appoint this, Lordship, petitioners as a normal teachers. They were appointed, Lordship. And Lordship, in their affidavit also, they have stated that they were appointed against non-government sanctioned posts. Therefore, after their regulation, after 2005, Lordship, they are entitled to the old pension since they are continued in their initial appointment was regular appointment, Lordship, and continued.
Yes, Mr. Mr. Chaudhary, you are appearing in which matters?
My lord, I think I appear in item number 22, my lord.
Only one.
Only one.
So what about the others?
Item 34 also.
Serious matter.
Oh, sorry, my lord, into number 28. In that series, I appear in one matter, that is item 34, my lord. 22 is a Mizoram different matter.
So why all these matters are different in category?
You know, to be honest, I'm slightly not aware of the things, my lord. Today I didn't come prepared in that matter. I requested one of my friend to. I'm sorry. No question. No.
After a week.
Yes, yes.
That may be fixed, Lordship. That may be fixed, Lordship.
Whatever the date, madam, ask for give that.
On 19th,
I am obliged, madam.
pass over matter 22.
One place. Page number to given.
Yes.
Lordship may kindly come to page 65. I'm giving the chronologically the events. So the Employee State Insurance Corporation, where the appellant was working, Lordship, he was granted deputation to the government of Mizoram in Health and Family Welfare Department. May I just read this letter? 28th January 2011. Issued by the Deputy Director of the Central Corporation to the Government of Mizoram. I am to refer to your office letter dated 7 January 2011 on the above subject and to inform you that the Director General ESI Corporation has acceded to your request to depute Sri Lalthanpara Medical Officer Grade 1 for a period of 3 years. It is further informed that the Director Medical Delhi, who is controlling authority of Sri Lalthanpara IMO Grade 1, is being advised to relieve him so as to enable the doctor to join Health and Family Welfare Department, Government of Mizoram. It is further added that the liabilities towards leave, etc. This is not very relevant. Now, on the basis of this, he was allowed to start his service on 10th of May 2011, page 66. Pursuant of ESI's letter dated 28/1/2011 and in interest of public service, the Governor of Mizoram is pleased to order posting of Dr. C. Lalthanpara, IMO Grade 1, Employee State Insurance Corporation, Ministry of Labor and Employment, Government of India, under Health and Family Welfare Department, Government of Mizoram on deputation at the pay band of so-and-so as per normal terms and conditions for a period of 3 years from the date of joining and until further orders. I'm skipping 2 paragraphs in between. Last paragraph. Dr. Sri Lalthanpara is directed to look after Rashtriya Swasthya Bima Yojana under Mizoram State Healthcare Societies. This is for specific purpose he was brought to look after the insurance activities of the scheme under Mizoram government. Thereafter, his service was extended. He had submitted an application on 28/3/2013 at the end of 3rd year for his absorption. May I read this also? To the Honorable Chief Minister of Government of Mizoram by Dr. C. Lalthanpara. With due respect, and I would like to state that I have been working in ESI Corporation, Ministry of Labor, Government of India since 2004, and I have been transferred on deputation from the Ministry of Health and Family Welfare Department, Mizoram, with effect from 11th May till 10th May 2014. I have been looking after RSBY and State Healthcare Scheme, which is the span in my posting here, have gained considerable improvement and popularity among the people of Mizoram and has been duly recognized by the Central Nodal Ministry and even won the state a national award for the same. Having said, sir, I would be very much like to continue to give my humble service to the people of Mizoram and the government of Mizoram in particular, even after expiry of my deputation period. And also, as my family is based here in Aizawl, I would like to be employed as a regular employee of Government of Mizoram on absorption basis under available rules and regulations. Also, I have been posted against the available post and pay head vacated by late Dr. Lal Laura, Civil Hospital Aizawl. My absorption will not entail creation of any new post as such. This was an application. Thereafter, it was extended, Lordship. In next page, that is on 6 June 2014, in continuation of the department's notification dated so-and-so and in the interest of public service, the Governor of Mizoram is pleased to extend the deputation period in respect of Dr. Lalthanpara for another period of 1 year, that is 11/5/2014 to 15/5/2015 on the same terms and conditions. Thereafter, what happened, Lordship? At the time of his extension period is over, a tragedy befall in his family. His wife passed away in a road accident, and he had two minor children. One is of 2 years, one is of 5 years. So he submitted an application that he should be kept because he was otherwise singly staying in Delhi with his wife and children. But here, all of a sudden, that unfortunate event took place. So he requested for absorption at the end of that period. When he was at the time of going back, this incident took place. So Lordship will kindly come to page 69. This application he has submitted to the Principal Director, Health and Family Welfare Department. This was on 14/1/2015. Prayer for absorption. As I'm reading. As you are aware, I so-and-so has been on deputation from ESI Corporation as OSD cum Senior Medical Officer, Health and Family Welfare and attaches Mizoram State Healthcare Society. My deputation tenure expires on 10/5/2015. While I was preparing to be repatriated, so he was ready to go back to Delhi. On my parent cadre, when my tenure expires, my wife met into a tragic accident and passed away on 10/10/2014 during that extended period. This led to a complete disarray in my preparation for repatriation, and I am forced to consider applying for extension of my deputation. But on verbal query to my parent cadre, further extension shall not be considered at the ministry. Therefore, Madam, I cannot but pray for absorption of my service into Mizoram Health Services with effect from 11/5/2015, given my dire family situation. As may be appropriate to mention that this absorption is, if considered, shall not entail creation of any new post, as I was posted against the post and pay head vacated by Dr. Lal Rohlua. I and my family would be grateful. So this application he submitted before the expiry of his extended period of deputation. The department also felt that his service is required. Therefore, the Principal Director, Health and Family Welfare Department, Mizoram government, on 14 January 2015, after receiving his application, wrote to the government, the Principal Secretary to the government of Mizoram. Please find herewith an application received from Lalthanpara regarding the subject cited above, which is self-explanatory for favor of information and consideration and necessary action. Further, I would like to mention that the said doctor during his deputation period under our department has rendered tireless efforts to ensure successful implementation of both RSBY, that is Rashtriya Swasthya Bima Yojana, and Mizoram State Healthcare Scheme. And he has also been an efficient and obedient officer. This is number one ground. Next, and also I personally feel that the reason for prayer for absorption into the Mizoram is worth considering, given his grave family crisis due to the untimely passing of his wife. So this was written to the government by the director. Now, this authority, the parent department was also informed. So the parent department was informed at page 71. So no objection was sought by the Mizoram government's department, Health and Family Welfare. May I read the third paragraph? Government of Mizoram has carefully examined his application and found it reasonable enough to allow absorption of his service into Health and Family Welfare Department, Government of Mizoram, under his good performance during his deputation and his genuine family problems. Honorable Minister, Health and Family Welfare has also given approval to absorption of his service. I therefore request you to kindly consider the matter sympathetically and issue no NOC for absorption of the service of the said prayer. And the second paragraph, Lordship will kindly see the age of the children. The second paragraph, the said doctor has applied to Government of Mizoram for absorption of his service into Government of Mizoram on permanent basis when his deputation term expires, citing a reason of his wife's tragically met with a fatal accident on 10/10/2014. And it would be very difficult for him to move back to his parents' department with his two little children, aged 5 and 2. So the ESC Lordship, page 72, has granted the no objection. I'm reading the last line. It is informed that ESI has no objection for absorption of services of Dr. Lalthanpara, IMO grade 1 into Government of Mizoram. Before going further, Lordship, I would like to place the rules, the relevant rules
because there is a relaxation. Under the existing rules in place, Lordship, there is no scope for absorption, but there is a scope for relaxation. Page 42, it starts. Their services are governed by Mizoram State Health Services Rules 2009. I'm just giving a cursory look to the relevant provisions. Rule 5, composition of the services, page 43. The services shall be divided into the following subcadre: General Duty Medical Officer, GDMO subcadre. Then 2, each subcadre will comprise of the following: General Medical Health Officer subcadre will comprise of MBBS, etc. 3 is relevant. Each subcadre shall have the following grades: GDMO, Dental Surgeon and Ayush subcadres, and serial number 1, special cadre, then grade 1, grade 2, grade 3. So at that point of time, the writ appellant, last paragraph,
Clause number 3.
3.
Each
5, 3.
cadet shall have the following grade.
Yes. So serial number 1 is special grade. Serial number 2, grade 1, grade 2, and grade 3. So the writ petitioners who are actually aggrieved by my giving the absorption, Lordship, they were working at that point of time in grade 3. And I was on deputation in grade 1. So we are not in the same grade. So the writ petitioners were in grade 3 and I was absorbed, or I was on deputation in grade 1. Now coming to rule 8, recruitment to the services. Recruitment to the services after commencement of this rule shall be the following methods: 100% of substantive posts in grade 3 of GDMO, Dental Surgeon, Ayush, etc. Grade, then B, lateral entry in specialist, etc. in grade 3 also. And C says lateral entry for super specialist in grade 1. Then direct recruitment is also there. Now coming to rule 10. Appointment to the service. This is the rule which was relaxed. All appointments to the service after commencement of this rule shall be made and notified in the Gazette by the government, and no such appointments shall be made except in the manner specified in Rule 8. All appointments to the service shall be made in the appropriate grades of the service and not against a specific post. All appointments of the services in the higher grades of time scale of pay shall be made only by promotion in accordance with the appropriate provisions under these rules, except those holders of degree or diploma of specialties, super specialties in a particular discipline, as specified in Rule 9, Sub-Rule 6 of these rules. Other things being equal, preference will be given to those persons having rural area experience of that of at least 1 year. Appointment. So basically what the rule says that there should be direct appointment, direct recruitment. Now coming to the seniority part, Lordship, at Rule 15. So various criteria were laid down here regarding the seniority. And regarding deputation, Lordship will find that at Rule 20, page 47. Filling up of duty posts by transfer on deputation, including short-term contract. So there is a provision of deputation is there. There is no provision of absorption. So I need not read it, Lordship. There is, the law is well settled and there is no dispute on that. Now coming to Rule 26, this has some relevance. Every promotion from lower grade to the next higher grade after the commencement of the rule shall be made by the governor from the confirmed members of the service on the basis of the recommendation of the commission, provided that all promotions shall be made strictly as prescribed in Schedule 5 of these rules, provided further that members of the service belonging to various subcadres, except in super-time grade, may be considered for non-functional promotion. This law is very important. Non-functional promotion within their respective subcadres in the form of financial upgradation to the next higher grade without linkage to vacancies, to ensure quality of service after completion of 5 years in the relevant grade according to seniority subject to satisfactory performance and non-availability of vacant posts in the promotion. So what is basically says Lordship, every 5 years, if their service is satisfied, then they will get the higher grade, even if there is no vacancy, they will get all the financial benefits of the next higher position. So as a non-functional promotion. So that provision is there in Rule 26. Now, by exercising the power under Rule 30, the impugn order was issued. Power of the governor to dispense with, amend, repeal, or relax any rule, where the governor is satisfied that the operation of any of these rules cause undue hardship in any particular case. I would refer to this, Lordship, because it is a particular case. Or that in the exigency of public service. Here also, I'm harping on this also, these two components. As well as for effective implementation of these rules, it is so necessary he may dispense with or relax or amend and repeal such particular rule or rules or any of the schedule of to these rules to such extent or subject to such conditions as he may consider necessary in consultation with commission, that is a public service commission, through the Department of Personnel and Administrative Reforms from time to time, provided that the case of any person shall not be dealt in any particular manner except under Article 311 of the Constitution, as may be less favorable to him than the provided by any of these rules. Provided further that any such dispensation or relaxation in any individual shall not be a precedent or binding policy of the government in any other case. So this is the relevant, these are the relevant rules, Lordship. And on the basis of this, the government have initiated the process for relaxation, and they have to take the opinion of the Public Service Commission. Public Service Commission. Page 76, 73. Yes, 72. Yes, I did. So we have already got the ESIC's Lordship NOC at page 72. Now coming to page 73. The proposal sent by the Department of Personnel and Administrative Reforms under Rule 30 to the Public Service Commission of Mizoram. So on 4th August 2015, that is a final proposal sent to the Public Service Commission. Proposal for absorption of Dr. C. Lalthanpara, so and so. I'm skipping the first two paragraphs, third paragraph. The department proposed that the aforesaid officer be absorbed within GDMO subcadre against the post vacated by Dr. H.B. James, special grade of GDMO subcadre, who expired on 13/9/2014. No objection from the employee state insurance company and comments, views of the concerned service associations were also obtained in this regard to the proposal. Annexure 1 and Annexure B. So the Doctors Association also given a no objection, Lordship, apart from the no objection from ESIC. The government, after careful consideration and deliberation, has decided to absorb Dr. Lalthanpara to the grade 1 of the MHS, that is the grade of Chief Medical Officer at so-and-so pay, with effect from 11/5/2015, and his seniority will be counted with effect from the date he has been appointed on regular basis to the grade of Chief Medical Officer in his parent department, that is 19/4/2013, and he will thus be placed at the bottom of the inter-se seniority list of grade 1 of GDMO subcadre. Copy of seniority list enclosed as Annexure 3. This entails relaxation to the provisions of Rule 10(1) and 10(3) of the MHS Rules 2009. I place both these rules now, Lordship. Comments of the Commission may kindly be offered in the matter. So this was a mandatory requirement under the rules when a proposal is sought to be granted for any relaxation. So the Public Service Commission was to be consulted. So on 12th of August 2015, page 74, 75 is in Mizo language. So I'm coming to the translated copy at page 75. So the Deputy Controller of Examination, Mizoram Public Service Commission, IJOL, wrote to the Under Secretary, Department of Personnel and Administrative Reforms, IJOL. I am directed to inform you the below mentioned information with regard to the subject mentioned above and letters referred above. The Mizoram Public Service Commission, after considering the proposal made by the government for relaxation to the relevant provisions of the recruitment rules for absorption of Dr. C. Lalthanpara, Insurance Medical Officer, ESIC Corporation, Government of India to Mizoram, has concurred the same. So the proposal has been concurred. So the Mizoram Public Service Commission was pleased to give the concurrence. And thereafter, on 24th August 2015, the impugned notification of the writ petition was issued. May I read it, Lordship? Page 76, 24th August 2015. In exercise of the powers conferred by Rule 30, that is the power of relaxation of the Mizoram Health Services Rules 2009, notified by so-and-so and published in the Mizoram Extraordinary Gazette. And in the interest of public service, the Governor of Mizoram is pleased to relax Rule 10.1 and 10.3 of the Mizoram Health Services Rules 2009 as amended for absorption of Dr. C. Lalthanpara, Chief Medical Officer of Employees State Insurance Corporation, Government of India, to grade 1 under GDMO subcadre of Mizoram Health Services and Family Welfare Department. This issue in consultation with Mizoram Public Service Commission, order dated 12/8/2015. Thereafter, another order was issued at page 77. His pay scale is given and the second paragraph. Dr. C. Lalthanpara will be posted in the Director of Health Services and attached to Mizoram State Health Care Society until further orders. He will draw his pay and allowances at the appropriate head, which may be specified by Principal Director in consultation with so-and-so. This issue with the approval of the DP and AR by order dated so-and-so. After issuance of this order, Lordship, the 4 writ petitioners, they were aggrieved and they submitted an application, which Lordship will find at page 80. The grievance regarding absorption in Mizoram State Health Services. So there's a request for reconsideration. I'm reading the last 2 paragraphs. The Mizoram Government Doctors Association have been consulted regarding this absorption. However, to my disappointment, absorption of Dr. C. Lalthanpara to grade 1 was done when steps were being taken as desired by MDGA for appointment as new entry grade 3. It is prayed that even if absorption of Dr. C. Lalthanpara is allowed, his seniority may be counted but treated as new entry in grade 2 at the earliest. However, if this is allowed as a precedent, then all Mizo doctors from other services will seek for absorption. Will all their interests be granted? So they were agreeing, although they were agreeing, but they were agreeing that his seniority should be counted from grade 2. But I was given the seniority at the bottom place of grade 1. These 4 persons, 82, the 4 persons are there. These are the
Substantive post held by the appellant in its original parent department.
It is at par with grade 1, at par. Page 132, that is also true. No. The appellant. Appellant's position. Now, medical association, no objection from both. One document I would like to place before making my submission on the impugned judgment. The association also granted the NOC.
Association?
The Association of the Doctors Association of Mizoram, they also given the NOC that he can be absorbed. So there is no dispute.
There was no need for that association.
But for that also, under the rules, it was not required. Under the rules, this public grievance and personnel department have to be consulted and they have to consult with the Mizoram Public Service Commission. That was done. Now, against this, the writ petition was filed, and the Honorable Court, Lordship, was pleased to find 2-3 grounds for allowing the writ petition. The basic grounds Lordship will find in the impugned judgment. Page 135, it starts. The basic submission is that paragraph 3, the petitioner council submits that Mizoram Health Services Rules 2009 does not have any provisions for absorption of a person into the services from outside the service cadre. And as such, even if Rule 10(1) and 3 of the Mizoram State Health Services Rules 2009 has been relaxed, the absorption of the respondent number 6 is divorced the Mizoram Health Services Rules 2009. The petitioner council submits that the respondent number 6 had initially been brought on deputation to the government of Mizoram under the Health and Family Welfare Department from the Employee State Insurance Corporation, wide notification dated so and so, so and so. Paragraph 5. The petitioner council further submits that no reasons have been given by the state respondents for relaxation of the Mizoram Health Services Rules 2009 to arbitrarily absorb the respondent number 6. So this is a submission they have made. I'll place the affidavits filed by them. And also the records. I have already placed those records. Those records were part of the proceedings, including the proposal sent to the Mizoram Public Service Commission, where 2 grounds are specifically.
Absorption was not permitted under the rules.
Under the note, there is no scope of absorption.
Then what is your ground?
There is a power for relaxation.
Relaxation until and unless the power is there, which power is to be relaxed? Absorption power is not at all there.
That is why, Lordship, why, if we look at the language of the relaxation,
Yeah,
if we look at it, in any particular case where the rule has to be relaxed.
which rule? The rule which permits absorption?
Yes, the rule is Rule 10 and Rule 8. The direct recruitment, that is the relaxation. That is why the impugn order says Rule 10(1) and Rule 10(3) are relaxed.
Rule 10.
Where is Rule 10? Let us see.
Rule 10, Lordship, page 45.
45.
These 2 rules are still relaxed, 1 and 3. All appointments to the service after commencement of this rule shall be made and notified in the office gazette, by the government, and no such appointments shall be made except in the manner specified in Rule 8. Rule 8 says recruitment to the service. So how the grade 3 posts were to be filled up? 100% should be direct recruitment. All this on this Rule 8 and 9. And Rule 3 says, 10(3) says, all appointments to the service in the higher grades of time scales shall be made only by promotion in accordance with the appropriate provisions. So this grade 1 also the promotion. So these 2 rules are relaxed. So now whether Rule 30 can be brought in. Now I'll go definitely, but the learned single just ultimately allowed the repetition on the ground. There was no ground cited. I'll come to that.
The learned single judge has concluded that absorption in the service is admissible.
No, it was like this, interfering with the impugned order on the basis that no grounds were cited. So we have two specific grounds.
But sir, Mr. Sekia, first of all, so you have to satisfy whether any person from a different service, central services can be absorbed in the Mizoram services or not. Any,
Under the rules, no.
then sir, under the rules, if it is.
No, that is why this power of relaxation is there. May I just read this sentence?
Relaxation in respect of application of some of the rules out of all the rules, but if they how can they
Rule, there is no bar.
a person can be entered into service.
Rule, it is like this, Lordship. There is scope for deputation here, but so far as absorption is concerned, it is silent. In 2020, they have amended and absorption is permissible now from 2020.
Mr. Saikia, please understand and appreciate the query of my lord.
What?
You see, a person can be born in a service in any of the methods prescribed by the rule. Could be direct recruitment, could be deputation, could be absorption or transfer, whatever.
Even regularization also.
Even regularization.
But now regularization is also never a permissible
Just a minute.
concept in any rules.
Just a minute.
Lord.
Now, whatever be the mode, that as court of law, we cannot question that. That is for the authorities to frame the rules. Now, your client in this case has been shifted to this, or he has been given a position in this service by way of absorption. The fact situation, reality is that is something else. We may have our sympathies.
That I'm not also too much stretching.
The question is, unless the rules permit that absorption is okay, one of the mode of recruitment or integration into the service, that normally cannot be done. But your argument is that because there is a power of relaxation, therefore by using that power, even though absorption was not a mode, the authorities have done it. We are pointing it out to you. You may address this issue. If you are ready, you can do it, or if there is an authority. By way of relaxation, you cannot legislate. You cannot create a norm which is not there. Say there is a norm which says this is the condition, and you relax the condition, that is another thing. But by relaxation of a rule, you cannot create a rule which is not there.
Absolutely.
So by relaxing a provision of Rule 10 or whatever it is, you can't read absorption into it when it is not there. That's what my lord is trying to indicate.
Absolutely correct. I fully bow down and agree to whatever he has fallen. But if we look at the language of Rule 30, the scope is little bit more here. May I read once more in a very slow manner? Power of the governor to dispense with, amend, repeal or relax any rule. Where suppose we are using this power of relaxation for amend or repeal also, or to relax, where the governor is satisfied that the operation of any of this rule cause undue hardship in any particular case. This is one particular case. Or that in the exigency of public service, the second part, Lordship, that his service was required for implementation of the insurance scheme in Mizoram, as well as for effective implementation of this I am not using. It is so necessary, he may dispense with or relax or amend or repeal such particular rule or rules, or any of the schedules to these rules to such extent or subject to such condition as he may consider necessary, in consultation with the Commission through the Department of Personnel and Administrative Reforms from time to time, provided that the case of any person shall not be dealt with in any manner except under Article 311 of the Constitution, as may be less favorable to him than the provided to any of these rules. And next proviso, further that any such dispensation or relaxation in any individual shall not be a precedent or a binding policy for the government in any other case. So here the government is formulating a policy. Here, a policy has been brought by the government.
Mr. Saikia, again, coming back to that point, it's a very subtle area.
Very subtle area.
See, these rules are under proviso to Article 309. These are framed by the governor in the name of the governor.
Yes.
Okay. Now, it is one thing to say the power of the governor to frame rules or amend the provisions. That is one thing. And the power of relaxation is with the government. While applying the rules, it is for the government to relax the stringency of the rule. Normally, whether it is mentioned here or not, if it is found that the rules operate to the detriment or creates hardship to any employee. For example, he can move on promotion but doesn't have a particular qualification. So relaxation of the norms of qualification or experience or
I
age.
understand.
These are a different thing. But here, what you are harping on, subject to what would be your final argument, you are saying that I have been absorbed. Absorption is permissible under the, is permissible only when the rules provide. So instead of the governor amending the rules under 309 proviso to provide for absorption, the government has relaxed the rules and read absorption into the rules, which was not there. So it is in that context we are putting the query to you. Hope you understand.
Here, I don't see any difference between the governor and the government. Here, the power of the governor to dispense with. Governor is doing everything at the aid and advice under Article 163 of the Constitution on behalf of the government.
It is not there. You have to have your opinion, ignoring the provision. But should be asking whether he wants to reflect on this point. Yes, exactly.
Would you like to go deeper into this point or conclude today?
No, I would like to address on this because Lordship is slightly expanding the scope of my argument. So I'd like to a little bit time may be given to me.
We are in fact restricting that you please address on this point. In the rules, when there is no
Yes.
provision, how can you say by relaxing that rule, a provision which is not there in the
Relaxing,
rules
Lordship, the relaxing, what I am trying to emphasize or harp is, Lordship, that it should be a direct recruitment or it is beyond the cadre also or promotion. We have thousands of cases where we are regularizing as a government policy. In those rules also, there is no scope for regularizing. All these things will be, so let me examine some of the cases where I can find that kind of concept where relaxation is given when there is particular concept is not there in the rule itself. Whether that can also be relaxed or not. From that point of view, Lordship will kindly give me a week's time, I'll address on this. But the learned single judge, while allowing it, Lordship, because it is an intra-court appeal and the learned single judge very clearly.
Those reasons are different. That we have seen.
Yes.
Learned single judges,
On a very narrow campus.
that you may be right.
But Lordship has
Fundamentally-
definitely has a, this is a valid
Fundamentally, what we are pointing it out,
Lord.
two things. First of all, the power of the governor to
Relax
make
up to what extent?
legislation under proviso to 309. It is a legislative function, correct? 309 legislation, it's not a plenary legislation, but it's a legislative function none the way. Source is recognizable to the Constitution of India. So if the governor wants to incorporate, repeal, amend, anything, add, delete, that is okay. That power the governor has. But subsequently, by invoking a provision of that rule, whether it is the government or governor, we don't think governor could have been the correct expression, but let's accept it for the time being. By relaxing that
It is
rule,
not his discretionary power.
No.
It is a constitutional power.
constitutional power, that one, 309.
Yes.
But by relaxing a provision of that rule frame under 309, whoever the authority is, whether it's the governor or government, cannot add words or recreate or legislate,
Yes, Lord.
bring in something which is not there in the original.
That is one
That's the
aspect of looking it. The reverse angle is that why this power of dispensing is given or relaxation is given. One is to whatever is there, you have to relax it. But whether we can bring something new, that is the query now.
That is the question.
Definitely, I will address on this. Lord. It is a new vista we'll have to look.
If the answer is in the negative, then you have,
Then I go back to Delhi.
then you have a road.
After 15 years, I will definitely have.
Go back to that, under the new rules, you can seek your absorption after having deputation.
Yes.
And again come back,
Again, come back.
because the government is your friend.
Well, I was also wondering whether by using power under Rule 30, something which does not even exist, that can be created
That is,
in vacuum and relax it.
This is one query. The other query, Lordship, was
No, and the other, it's all the
corollary.
same. You relax a rule to mitigate its rigors. So that's
we
the
look at from the perspective that we are relaxing because we cannot give him direct recruitment at this stage. So
That's
that
right. So that's
that is
where
why
it comes in.
10.1 and 10.3 is relaxed.
You cannot do something. See, the conditions of recruitment cannot be relaxed. Rules of recruitment cannot be relaxed. That's
Absolutely.
Mr.
Eligibility
Chaudhary
criteria
has
cannot
the
be
judgments. Mr. Chaudhary,
Yes, yes.
you have the judgments. Rules of recruitment cannot be relaxed.
What can be relaxed is condition of service.
Condition of service.
As the lordship just pointed out, suppose
Now this is
some
not
experience qualifying service is required,
conditional.
then by applying these provisions, it can be. But my lord, a preliminary fundamental requirement that cannot be.
No, Mr. Saikia, examine it
Yes.
because division bench judgment means we have to deal with the law. It's not
Absolutely.
about one case here or one case there. Law has to be consistently so enunciated. So look into it,
Definitely.
and you may find these judgments that where rules of recruitment cannot be relaxed. Even if it
Then
was
that is a settled position of law. Rules of now whether it is a recruitment or not.
recruitment means induction.
it's a kind of recruitment.
Induction. The
It's a
reason is
Mode of recruitment. Which is not there
Whether
in
we
the
can
rules,
put
which is
the
not there in
absorption and deputation in the same footing as recruitment or not. That also I will try to look
that
at.
you see, but
Yes.
why it is relevant? Because there is a facet of Article 16 which will be complained by others, which is exactly what is happening.
My lord, there is another limb of this case, my lord. In para 23 of the writ petition which he pleaded, we were in grade 2, my lord. He was inducted into grade 1. So our condition of service has been valid. That's what. Para 23, page 39.
That's what I have just.
After a week.
Lord.
Yes. Deep level.
Item 46 and 47.
Baru gimana saya?
Advertisement. Muta langsung jadi. May please your lordship. This is another matter relating to recruitment. It's a direct recruitment issue. And the advertisement is at page 67. In the All India Institute of Medical Science, AIMS Guwahati. The advertisement was issued on 5th of October 2021 for various posts, and we are concerned about the subject microbiology, which will be about 12 from below.
Yes.
In microbiology, 2 categories of posts were advertised. One category is 4 categories. We are concerned about 2 categories: associate professor and assistant professor. In associate professor, there is 1 unreserved category post and total post is only 1. And in assistant professor, there are 2 posts, 3 posts, 2 unreserved, 1 SC. In pursuant to this, we have applied
Post of the associate professor, 2 posts.
two posts of associate professor. 1 is reserved, 1 is unreserved.
And
Sorry, I'm extremely sorry. Let's say 1 post only, that is unreserved. And so far as assistant professor is concerned, there are 3 posts. 2 are unreserved, 1 is reserved for SC, scheduled caste. And we belong to unreserved.
microbiology, we are not concerned with the professor and additional professor.
No, we are not, lordship.
We are concerned with the assistant and associate.
Associate and assistant, lordship.
So there is 1 post for associate professor that is unreserved,
Yes, lordship.
and
3 posts.
3 posts for associate professor, out of which
Assistant professor.
2 are unreserved and 1 is for SC.
SC. In the tabular form, it is given, lordship, at page 67.
Yes.
And the eligibility criteria are given at page 70. And page 73, lordship will kindly come. Shortlisting and method of selection. Here the issue is regarding selection method.
73.
Page 73. At the top, serial number 16.
Yes.
Shortlisting / method of selection. The prescribed qualification is minimum and mayor possessing the same does not entitle any candidate to be called for interview or for selection. Based on biodata, the screening committee may shortlist candidates for interview. If required, there can be screening tests to shortlist candidates for interviews in case large number of candidates apply to a post or post. Candidates called for the interview will have to produce all relevant original documents in proof of details furnished in their application at the time of interview. They may also be asked to submit affidavit declaration as decided by the AIMS, Bhubaneswar, at time of interview. The methodology, this is relevant, lordship. The methodology of selection will be decided by the selection committee as deemed fit, besides any other matter relating to the selection process. So the discretion lies with the selection committee regarding the mode of selection. So all the applications were submitted by the various candidates and a list was prepared, short list was prepared. That lordship will find at page, it starts at 84. On 21/3/2022, revised list of provisionally eligible candidates for recruitment of faculty posts, professors, additional professors, associate professors, assistant professors in various departments of AIMS Guwahati. So we are concerned about the Department of Microbiology that lordship will find at page 90.
This is the notification.
Device list. So there are 2-3 lists. Finally, this was the list from where the candidates were in called for interview.
Page 90.
Page 90, Department of Microbiology.
Yes.
So the writ petitioner's name, Vikramjit Datta, at serial number 12, page 91. This is in the category of associate professor. 1 post unreserved, associate professor. So Vikramjit Datta, he was a writ petitioner. His name at serial number 12. 13 is Kaushalla Raghavan. and 14 is Rajeshwari S. Rajeshwari S is the appellant herein. And identically, assistant professors list also is there. Vikramjit's name figured at serial number 19. And appellant's name figured at serial number 28, Rajeshwari S. We are representing Rajeshwari S. Lordship. Thereafter, on 5th of April, page 102, the interview schedule was released. 102. Notification interview schedule for recruitment of various faculties of AIMS Guwahati with reference to the advertisement dated 5th of October 2021. Following is the tentative schedule for interviews for selection of faculty post of professor, additional professor, associate professor, assistant professor in various departments of AIMS Guwahati. The interview will be conducted in physical mode only. The tentative schedule of the interview is as follows. Serial number 5. So all these posts, professor, additional professor, associate professor, and assistant professor of microbiology, the time schedule was fixed at 7 a.m. on 23rd of April 2022. The venue is Director's Boardroom, ground floor, Administrative Block, AIMS Guwahati. There was no separate timing for the separate post at the interview. So everybody was called at 7 a.m. and it started. So both these posts, associate professor, assistant professor, along with the other two posts, that is post of professor and additional professors, all were called at that point of time. So interview was conducted and the provisional result list was issued on 9th of June 2022, page 104. The relevant portion regarding Department of Microbiology, Lordship will find it at 107. Department of Microbiology, Associate Professor. So Deep Jyoti Kolita was selected at serial number 1. There was only one post and Vikramjit Datta is waitlisted 1, the writ petitioner.
Yes.
So Deep Jyoti Kolita was selected. He is not a party. No? So there is no dispute on him. So Vikramjit Datta, he was waitlisted number 1 in the category of associate professor. And second waitlisted candidate is Kaushalya Raghavan.
Yes.
Respondent number 5 in the writ petition.
Yes.
And regarding associate assistant professor, where there are 3 posts, 2 unreserved, 1 reserved, the general candidates whom were selected, Kaushalya Raghavan and Rajeshwari S. So I was selected as the second candidate as assistant professor in the category of unreserved. And Manish Ranjan and Orup Mohanty waitlisted. So the writ petitioner's name did not figure here.
In the category of assistant professor.
In the assistant professor, his figure did not figure, and that
Professor, he was waitlisted 1.
yes,
And assistant professor is.
he is not in the scenario. So his whole case is based on that. When I can be waitlisted number 1 in a post which is considered to be higher than assistant professor, that is associate professor, how can his name be not there? He should have been an automatic entry. That is where the learned single just
Yes.
He sought a RTI reply regarding this selection. That page 133. And I will take this honorable court to the affidavit filed by the Ames, where the complete data, the process, how each individual expert was giving marks, how the minutes went ahead, everything will make it very clear that there are two interviews. There was not single interview. And the learned single judge went on the premise that there were single sets of questions. It is not correct. That is the area.
133.
133. So this is the reply given to the writ petitioner.
Yeah.
Recommendation of the standing selection committee. As per the minutes of the meeting of the standing committee for the selection of associate professor, the Department of Microbiology at Ames Guwahati on regular basis held on 23/4/2022 in the director's boardroom, ground floor so and so. The following candidates are recommended for the post. Deepjyoti Kolita selected, Vikramjit waitlisted 1, waitlisted 2, Kaushalla. Identically for the next post, that is assistant professor, Kaushalla Raghavan selected, 2, Rajeshwari selected, and 3, Manish Ranjan and Orup Mohanty. The writ petitioner's name did not figure. Now coming to the next page, the marks they have obtained. Vikramjit Datta, writ petitioner, his average mark scored in associate professor 67.3. He was waitlisted 1. Kaushalla Raghavan 66.8, waitlisted 2. Rajeshwari S. appellant, she got 62, so she was nowhere in the picture. She was not even waitlisted in the category of associate professor. Now coming to the assistant professor on the right hand side, Vikramjit Datta got 63.1, Kaushalla Raghavan got 68.2, and 67.0 was Rajeshwari. So 68.2 and 67 got selected, and Vikramjit was not there.
No, but how was it? 68.2 and 67 got selected.
Yes, and
he is
63 did not.
68.
63.
Oh, it's just 63.
There were 2 posts in the general category.
ये क्या 63 or 68 है 63.1 is it?
63.1. The top one is 63.1. So in the RTI, they ask in the marks in a sequence. So in that sequence, it is not the order of merit.
Okay.
So Rajeshwari got, that means the appellant got 67.0. The other person who was selected at serial number 168.2.
Was also waitlisted number 2.
Sorry.
In the category of associate professor, she was waitlisted candidate number 2.
Yes, Lordship. Yes.
But where are the marks of Manish Ranjan and Anup Mohanty?
I'll give the complete markings, Lordship. That is that.
You have not asked for their marks, na? In the RTI, you have not asked for their marks.
No.
Yes.
Yes, Lordship. How the marks were given, the consolidated marks, we find, before going to that chart, Lordship, I'd like to place what exactly is the stand of the Ames.
But combined interview हुआ है लेकिन अलग-अलग तो मतलब पैरामीटर्स अलग
Yes.
Lordship, I'd like to definitely go to the affidavit file where the complete picture is given. How the learned single judge proceeded, paragraph 16, page 262. That the foundation or the premises on the basis of which the judgment was delivered, there was a flaw at the very beginning.
Para 16.
Para 16, page 262. After hearing the learned counsels for the parties and on examination of materials on record placed before this court, certain undisputed aspects are noted in the following manner. The interview for the post of associate professor as well as assistant professor in the Department of Microbiology AIMS was fixed on 23rd of April 2022 at 9 a.m. It should be 7 a.m.
Which page is the judgment?
Page 16, internal page will be 8.
No, the judgment is start from which page?
I'm sorry. It starts from 255.
255 is something else here.
There may be two.
255 is something else.
255. Or maybe the AIMS also filed an appeal.
Aims file. na?
Which is your writ appeal?
Mine is lordship.
Aims file में कितना number है?
Ours is 258.
467. 467 तो number ही नहीं है भैया.
Where is the judgment? Which page is the judgment?
Judgment lordship page, it starts from page 24.
24.
24. Right? 24.
इसका page number ये था. Yes.
Paragraph 16. After hearing the learned counsels for the parties and on examination of the materials on record placed before this court, certain undisputed aspects are noted in the following manner. The interview for the post of associate professor as well as assistant professor in the Department of Microbiology was fixed on 23/4/2022 at 9 a.m. For both the post of associate,
7 a.m.
It should be 7 a.m. Lordship. That is why, that is a minor, maybe a typographical. I'm not on that. I'm not making a submission also. 2 and 3 were wrong. For both the posts of associate professor as well as assistant professor, only one interview was held. This is an incorrect observation of the learned singles. I'll place it from the affidavit. And number 2, for the common interview, it was not a common, it was separate interview held. For both the posts, there was one set of question. So it was an interview. There is no question paper at all. So these 2 points, that one interview was held. There were 2 interviews, number 1, and 1 sets of question. These are incorrect facts on the basis of which the learned single judge proceeded.
Yeah.
Paragraph 17. When admittedly, it was not admitted by us at least. I do not know the aims also will definitely, their affidavit is totally different. I'll place the affidavit which was before the learned single judge. When admittedly one interview with 1 set of question was there for the candidates, including the petitioner and the private respondent who had applied for both the posts of associate professor and assistant professor in the Department of Microbiology, it is failed to understand as to how 2 assessments could have been made. If in the assessment made by the higher post of associate professor, the petitioner was assessed to be better than the private respondent by allotting him more marks, it cannot be reasonably conceived that for a lower post of assistant professor, the petitioner could be assessed as inferior to the private respondent. The learned counsel for the respondent have strenuously argued that the petitioner is stopped from making a challenge after he had participated in the interview without any demur, and only because of the fact that he has turned out to be unsuccessful, the challenge has been made. In this connection, I am not on that. If we can skip this. Next page, top line.
Yeah.
This court is, however, of view that the cause of action of the instant case is not in the manner of holding the recruitment process by means of 1 interview. The challenge is rather on the making 2 assessments in a common interview, and such action could be revealed only after publication of the results and upon obtaining the necessary information with regard to the marks secured. This court, upon examination, has found that the grievance of the petitioner is not related to holding a common interview, but only on making two assessment in a common interview, and such a course of action adopted by the authorities could be revealed only after publication of the results of the selection, obtaining.
Just.
I'm sorry.
Yes.
This court upon examination has found that the grievance of the petition is not related to holding a common interview, but only on making two assessment in a common interview. And as such, a course of action adopted by the authorities could be revealed only after publication of the results of the selection and obtaining the details of the marks secured by the incumbent. Coming to paragraph 21. It is seen that while in the appointment made to the post of assistant professor, the first nominee is the respondent number 5 and the second nominee is respondent number 6. Since the petitioner was assessed to be better than the aforesaid two respondents in higher category of associate professor, the petitioner has to be given the benefit of appointment as assistant professor as being assessed as better than the other said respondent number 5 and 6. Consequently, the respondent number 6 has to give way to the petitioner to be appointed as assistant professor in AIMS Guwahati. The appointment of the respondent number 6 is accordingly interfered with, and the petitioner is directed to be offered the appointment of assistant professor in AIMS Guwahati pursuant to the advertisement dated so and so. My appointment was set aside. But however, a handle was given to AIMS that if they can increase one post and accommodate me, that is, I'm not on that. I do not want that handle. Now, what exactly was in the affidavit? The records were loud and clear, Lordship. There is no ambiguity.
Yes.
The few paragraphs from the affidavit I would like to place.
Affidavit?
Affidavit filed by the AIMS, page 168.
Sir, you please have the file of Mr. Gogoi, because we are looking into that.
I'm sorry, at the very beginning, I should have.
Yes, you should have.
Actually, I thought my number is earlier, so anyway, I'll take this.
Earlier, his case is listed first. 46 is his case, Mr. Gogoi's case.
Mr. Sekar,
135.
the numbers do change sometime. And very unexpected, very unexpected.
135, but I'll carry on because I have highlighted the relevant portion, but I'll give the page number, Lordship. 135.
Yes.
Have Lordship got it? The affidavit. So paragraph 5.
Yes.
As regard to the statements made in paragraph 2, the deponent begs to state that the selection process was based on the candidate's performance in interview conducted by the standing selection committee and the subject experts. As per the assessment by the interview board, the marks were awarded separately for the post of associate professor and assistant professors to all candidates who appeared in interview. Listing of selected and waitlisted candidates were strictly based on the marks awarded by the panelists as per their individual assessment and summation thereof. The whole process has been conducted as per the said procedure. Hence, no illegality can be committed. Coming to paragraph 7. The deponent begs to state that the petitioner was called for the interview for the post of associate professor and assistant professor. The interview for the post of associate professor and the assistant professor was conducted in immediate succession by the standing committee, panel on 23/4/2022. Separate attendance sheets and separate assessment sheets were maintained. Annexure A, Lordship, for the time being, that Lordship will find. I'm not a peaceful area. 145. So here, candidates attendance sheet for interview associate professor, the names, relevant names at paragraph serial number 12, 13, 14, Bikramjit Dutta, Kaushalya and Rajeshwari S. So their attendance were taken for the interview of associate professor at 12, 13, 14. And next page, assistant professor,
12, 13,
12, 13, and 14.
Page 145.
14 is the appellant and 12 is the repetitioner.
This is associate.
And assistant professor, next page.
Yeah.
My name, Lordship, no, serial number 13 is Kosh Raghuvan. And 19 is Vikramjit Datta, 1919. And 28 is Rajesh Suri S, myself.
Fine. This is the attendance sheet.
Attendance sheet. And I'll go to the separate assessment sheet little bit later, Lordship. May I continue with that? Paragraph 8, page 137. The results of the interview for the post of associate professor and assistant professors were declared based on the compiled mark as were awarded by individual panelists separately for this post. Respondent number 5 and 6 secured more marks in assessment for the post of assistant professor, while the petitioner secured more marks in assessment for the post of associate professor. Then, paragraph 9(1) RTI, the officer who gave the reply, he said that it is one and same interview. That actually give them the handle to file this case. So I'd like to read this also. The interview for the post of associate professor and assistant professor in microbiology was conducted together by the standing committee on 23/4/2022, which was mentioned as one and same to the specific query in RTI application of a third party named Sri S.K. Deuri. As a matter of fact, separate attendance sheet and separate assessment sheets were maintained for the interview for both the posts. So same day, the notice was same. That is why that particular RTI officer gave this reply. But that will not change the actual contemporaneous records. The records are very clear. Now, paragraph 10, we refer to that in clause 6 of the general conditions of the advertisement, it was clearly mentioned that the methodology of selection would be decided by the selection committee as it deemed fit, besides any other matter relating to the selection process. Accordingly, the standing committee assessed the candidates for both the posts in the interview conducted in continuous sessions. Thus, the deponent denies petitioner's allegation of non-adherence to the methodology of selection in as much as same was communicated in the advertisement for recruitment dated 5th of October 2021. 11. The deponent, while reiterating and relying the statements made in paragraph 10 of the affidavit, denied the petitioner's contention that the candidates who qualify for higher posts automatically becomes eligible for lower posts. Though same selection committee interviewed the candidates for both the posts, but separate assessments for each of the two posts were made by the selection committee, and as such, qualifying in one post does not make the candidates qualify for the other post. Next page, Lord. Coming to paragraph 12. Well, the deponent begs to state that in 3 departments, the candidates placed as serial number 1 of the waiting list were selected in the post next lower order as follows. So this is not very relevant. However, this shall not be treated as defined order. Rather, it was a coincidence, and based on the marks awarded to the candidates by standing selection committee, selection was done against the particular post. 13. The eligibility and selections are different aspects. Based on eligibility, a candidate cannot claim selection. The selection committee made individual assessment for both the posts separately. Each member in interview panel awarded marks separately, and these marks were summed up and averaged for deciding the merit of the candidate. Thus, the process adopted in the selection of candidate is reasonable and justified. Coming to paragraph 17. The deponent begs to state that the post of associate professor and assistant professors were conducted on 23/4/2022 by the standing selection committee in a single session upon informing about this to the candidates attending the interview and having recorded the attendance separately, one for associate professor and other for assistant professor, in the prescribed attendance sheets. Similarly, marks were awarded in 2 separate mark sheets by the standing.
You understand that separate interviews conducted, separate marks were given, though by the same
Yes.
panel.
And Lordship will kindly see how the marks were given by each of the Page 195 to know that. Consolidated mark sheet. Good. Good. 167. 157. Select where, so. The committee, the selection committee, now it is in the case of associate professor. 162. The committee consisted of chairman is Dr. Tulsi Bhattacharya. So he gave marks, then Professor Babul Bejbura, vice chairman, he gave marks, then all the members, they gave marks to each candidate. If Lordship is pleased to come to next page, serial number 12, Vikramjit, how his 67.3 marks came by getting the average of the marks given by the various panel members. Vikramjit Datta got 67.3. Kaushalya Raghavan 66.8 and Rajeshwari 62.0. So she was not in the scenario. This is in respect of associate professor. There was only single post, so one person got it. Deep Jyoti Kolita, serial number 2, he got 70.7, so he got the offer. Serial number 2. And next page is 164, the consolidated mark sheet of for assistant professor. Here, serial number 13 is Kaushalya.
Yes.
So Kaushalya, she got 68.2. She was selected candidate number 1. Serial number 13. And Vikramjit got 63.1, serial number 19. And I am at serial number 28, 67.0. And waitlisted candidates are also there, 33, 36. So Manas Ranjan, he got 65.4. And
Yeah, separate assessment.
Everything separate.
Marks, everything was separate, yes.
And the minutes also very clearly says separate. Minutes are also there for separate.
Where is that?
We have, yes, 157.
In his petition, in his writ appeal. 157.
Yes. Associate professor, 152 associate professor.
152 associate professor.
Lordship.
Yes, what it says?
Lordship will see the panel, the committee.
Yeah.
It's a very highly placed committee, Lordship.
Bhattacharya, Babul Bejbura.
Then Director General of Health Services, Ministry of Health Affairs, Government of India. Then Professor Dilip, Vice Chancellor, Assam University, Professor Rangarappa, Indian Science Congress Association, Professor Noren Babu, Department of Anatomy, RIMS, Imphal. Then Professor Ramji, Executive Director, AIMS, Kalyani. Professor R.T. Kapil, Department of Microbiology, AIMS, Delhi. These are 2 experts, subject experts, 8 and 9. And Captain S.P. Singh, Department of Microbiology, AFMS, FMC, Pune. And their second page on top, the selection committee was provided with the applications, biodata, and copies of the certificates of the eligible candidates who attended the interview for the post of associate professor. Attendance of the candidates is attached. After perusal of the same, the committee has conducted the personal interview of the candidates who appeared for the interview. The selection committee has decided that the total mark for the selection is 100 marks. For the interview, the cutoff mark for selection is of under reserved category 65. The selection committee has evaluated the performance of all the candidates in the interview who attended the interview and awarded marks as per attached mark sheet. It is also certified that none of the candidates shortlisted for interview are related to the chairman, members of the committee. Based on their personal interview marks, the selection committee recommended the following candidates as per their merit for appointment to the post of associate professors. Under reserve category, Deep Jyoti Kolita, he got 70.2, so he got selected, and waitlisted are two others. Vikramjit is the petitioner, and Lordship will kindly see their signatures on that page and those some signature on the other page. Then identically, 157 assistant professors minutes. Here also same language at the last paragraph. And I'm coming to the next. The cutoff mark, next page top line, the cutoff mark for selection of under reserved category is 68.5, 63.5, and for SC category is 50. The selection committee has evaluated the performance of all candidates in the interview who attended the interview and awarded the marks as per attached mark sheet. So here the selected candidates are Kaushalya Raghu Raman and Rajesh Suryas, both are selected. Waitlisted are Manish Ranjan and Arup Mohanty. He got 63, who is not in the waitlisted also. And the learned single just allowed him to join. There are persons in between him also. So only thing is that on the same day, all the candidates were called. One after another, the two separate interviews were taken. Separate attendance sheets were signed. Separate minutes, separate markings by the committee. For each individual was given. And the expert committee and the members' marks were all collected and scrutinized and tabulated, and it was done. So the basis on the which the learned single proceeded in my humble submission cannot be assessed from the facts which are part of the affidavit.
Yes.
Deeply obliged, Lordship. I have some judgments which are covered, Lordship. Basically, it is a settled law.
Minute, please, your lordship. Just I pointed, just I pointed two, three things, and lordship, the judgment lordship, which I am relying lordship.
Judgments?
Judgment.
What are those judgments?
Judgment lordships. I'm relying lordship, the one of the recent judgment of the Honorable Appeals Court lordship. That was passed on lordship on last August 21, 2024 lordship.
Was the
It's a lordship, civil appeal number 50512023. Rekha
what's the
Sharma.
proposition of law laid down?
Proposition of law, it says that lordship, as a well settled candidates who consciously took part in the process of selection cannot be permitted to question the advertisement or the methodology adopted by the respondents for marking the selection as well as their own declaration of unsuccessful candidate. Lordship.
Aware of that.
Lordship. And another also lordship, all the earlier judgment was discussed in this case, lordship. It is in 2023 SCC online SC344 lordship.
Yeah.
It was written by my Lord Justice A.B. Nagaratna lordship. I am relying paragraph 65 that I did it. 2023 SCC online SC344.
Yeah, what it says.
Para 65 onwards, lordship.
Yeah. Selection process by the court.
Lordship.
Okay.
And 66, 67, 68, and 69, lordship. I'm relying paragraph.
While excellent judicial cannot step into the shoes of selection, can assume that appellate rule or examine. Yeah.
And 68, lordship, all the earlier judgment was discussed in the paragraph 68, lordship.
Fine.
Paragraph 68, lordship.
Yes.
All the earlier judgment was discussed by the Honorable Appeals Court, lordship, then 69, lordship.
Yes.
Yeah, 69.
These are two judgments.
Other judgment also there, lordship.
Other judgments are relevant if one judgment is sufficient.
Lordship.
Why if you are referring to more judgment, then it
Regarding
means your case is weak on merits.
Regarding expert view, lordship, I am relying on one judgment, lordship, only one judgment, lordship. Air 1990 Supreme Court 434 paragraph 9, I am relying, lordship. And two things I am just relying, Lordship, just for Lordship. The recruitment notice was issued, Lordship, on 5/10, my lord, may kindly note, 5/10/2021, Lordship. And notification for interview was issued on, Lordship, 5/4/2022, Lordship.
Fine.
And notification of select list was published on 9/6/2022, Lordship. An appointment was made on 10/6/2022, Lordship. And writ petitioner filed this writ petition on 10/1/2023, Lordship.
By that time, he was collecting the.
We have already selected, he has participated, Lordship. And
ये कितना समय लगाएगा? ये तो खत्म नहीं होगा, ये कितना समय लगेगा? मेरा सिंगल बैंक उसको तो टाइम देना पड़ेगा।
Nee, this 90 judgment, why you are referring to this 90 judgment?
90 judgment, paragraph 9, Lordship.
What it says?
Paragraph 9, it says that, Lordship. It will thus appear that apart from the fact that the High Court has ruled the cases of the two appointees in one, though their appointments are not accessible in the same ground, the court has also found it necessary to sit in appeal over the decision of the.
This judgment says the very same thing.
Lordship. No.
Why you are referring to all these judgment points? The judgment is already there. One is
Lordship.
One judgment is sufficient. Why you are just throwing the judgments on the court like anything?
Only one thing, Lordship. I was working in Kerala in a government job. I resigned and I have come and joined here.
You belongs to this place only. Your client belongs to this place.
No, I do not belong to.
So you belong to that place.
So I got the job and after 6 months it was challenged.
So there is some interim protection now.
Yes, there is interim protection. If I am not given the relief per se, I will be nowhere. I have lost my job in Kerala as well as in.
This judgment, once judgment on your analogy is sufficient, and then after this judgment, you are also not in requirement to submit any more.
No, I am solely relying upon my facts. I'm on facts.
Yes, Mr. Das.
Yes, ma'am. Lord, at the very beginning, Lordship will kindly bear with me. I have also marked my pages with regard to the writ appeal of my senior, Mr. Sakia. So I'll be little late in giving the pages, my lord. Lordship will kindly bear with me.
Have Mr. Sakia with you?
Oh, no, it's not required, ma'am. I'll give. Lordship will kindly come to the advertisement for a moment first, my lord. The page number is 67, my lord.
Yes.
Microbiology, 3 posts of assistant professor, 2 posts of associate professor. Now, my lord, will kindly come to page 69.
69, yeah.
This is with regard to the qualifications for both the posts, my lord.
Fine.
Essential for medical profit. No, 60, no, 70. Page 70, the qualification.
Assistant, associate and assistant professor.
Associate and assistant professor, experience 6 years teaching, or research experience in recognized institution in the subject of specialty after obtaining the qualifying degrees of MD, MS, or a qualification recognized equivalent thereto. Experience down.
Mr. Das, what is the submission? Can you tell us first before you go into?
First of all, my lord, I'll establish before your lordships there were no 2 separate interviews. Their entire crux of the argument is that there were 2 separate interviews, separate assessments were made. So there is no illegality in the assessment process or decision-making process. My lord, that is absolutely incorrect, my lord. I'll show from the records itself. That's why the learned single judge has written everywhere that it is an admitted factual position that no interview.
Show that.
My lord, why I'm saying so, why I'm indicating this experience and qualification, the reason is that, my lord, there is a finding by the learned single judge that you have selected the person or you have shortlisted the person for the post of associate professor, but you have rejected his candidature for the post of assistant professor, which is a lower post.
So that
So for that, no, I'm not on that.
There are many instances where a person appeared for the interview in a lower post. He was not selected, and in the higher post he was selected, and vice versa also.
My lord, what I'm trying to emphasize before your lordships is that for the experience and qualification that was mandated in the advertisement for the post of associate professor were much higher than the
Then-
post of
then-
assistant
then-
professor.
Then you are forcing us to go into, to assume that the person who is selected on the post of associate professor is bound to be selected for the post of assistant professor.
No.
Despite his performance or whatever it may be, he is bound to be selected since he was selected for the higher post.
No.
So lower post he is bound to be selected.
In fact, examples were given by the Ames itself in their affidavit. Three examples,
Yeah,
including, yes, three examples and including one of the respondents involved herein. That is my submission.
Sorry to say, for that purpose, that they have selected so person, you have to plead Malafides, that on account of Malafides, you have been ousted and this person was selected. Simply on the basis of this, that you got more marks in the interview of the associate professor, and therefore and the person who was selected as an assistant professor got less marks in that interview.
All right,
Therefore,
I'll,
you are supposed
I'll try to persuade.
to stretching is too far.
Fine, my lord. I'll just skip this point for a moment. I'll come to the next point immediately, my lord. Lordships, page 71, if your lordships kindly take up.
71.
I'm sorry, my lord. It will be 71. Yes, my lord.
Yes.
In case a candidate wishes to apply for more than one post, she is required to fill the form separately through online mode, only followed by offline application as prescribed, and separate application fees as applicable to be paid.
Yeah.
So they can apply both the posts. They have applied. Then my lord will kindly come. The application submitted by the writ petitioner, page 76.
76.
This is the application submitted by the writ petitioner for the post of associate professor, and page 80. It will be yes. Page 80 is the assistant professor.
Yes.
Application. The experience and qualifications your lordship will find page 81A of the writ petitioner, my lord.
Yes, you are having.
He was serving in Ames, Delhi, Ames, Safdarjung, then Milord Safdarjung Hospital. Lastly, there, and prior to that, he was serving in Ames, Delhi.
Fine.
Then your lordship will kindly come page 84. The notification revised provisional list.
Yes.
And relevant will be page 90. My lord.
90.
Huh? 90. Department of Microbiology.
Yeah.
And page 91, my name at serial number 12.
Yes.
And 13 and 14 were the respondents.
Yeah.
Then assistant professor, serial number 13 is one of the respondents, and 19 is the writ petitioner, and 28 is the appellant.
Fine, they already mentioned it.
Fine, man. I'll just keep then, my lord, whatever has been placed before your lordships. Then page 102 is the interview schedule. Microbiology was scheduled on 23/4/2022, and it was at 7 a.m. My lord, this 7 a.m. is subsequently changed. That's what there was no error.
Judge has mentioned it to 9 a.m. Okay.
Yes, yes. Now, my lord will kindly come. Why I am saying that there were one interview and two assessment.
Yeah.
Lordship will find in the RTI reply, that is annex, my lord, page, it will be page 116. 116.
Earlier.
He submitted an RTI application, my lord, pursuant to which a reply was furnished.
Yes.
116 C. C.
116,
serial number 5, my lord.
yes.
Whether the interview for the post of associate professor and assistant professor were conducted separately, or there was one and same interview for both the post,
One and the same.
one and the same. So there was no separate interview, my lord.
Fine.
Now, your lordship will kindly come
Yes.
lordship will kindly come to page 178, my lord. It will be 145. In your lordship's brief, my lord, it will be 145, my lord.
145.
Yes, lordship.
What is it?
My lord, this is the attendance sheet.
Yes.
Lordship will kindly refer date and time of interview. This is for the post of associate professor.
9 a.m.
23/4/2022.
9 a.m.
9 a.m.
Yeah.
Now, my lord, we will kindly come to next page.
9 a.m.
23/4/2022. 9 a.m. So how can they say that there were two separate interviews, my lord? There were, in fact, in their affidavit also, they have admitted that there was no.
Can be they said then they have already notified that we'll interview for these posts at 7 a.m. on 22/4, whatever
23/4.
the date may be on 22. Hey, then and there you should have challenged it. How can you have interviews for the post?
No, it was not at all. No, it was not at all within my knowledge, my lord.
Within notice, this was the notification, sir.
No, lordship, they.
This
I'm
is
sorry,
the
my lord. Like,
notification. This page number?
page 102.
102, what it says?
It doesn't say, my lord.
It says with reference to the advertisement, so and so following in tentative schedule of interviews for selection of faculty or post of professors, additional
Yes.
professors, associate professors and assistant professors in various departments of the order will be conducted in physical mode only. The tentative schedule of the interview is as follows. This is what the tentative schedule.
And department is microbiology. On 23/4/2022, they have conducted the interview department wise, not post wise, my lord.
Sir, department wise, all departments interview were scheduled for 7 a.m. on different dates. Here
Yes.
on 23/4/2022, 7 a.m. they fixed for microbiology for the post of professors, additional professors, associate professor and assistant professor. They mentioned it. It clearly says that the interview for all the posts advertised in microbiology would be held on so and so date at this time.
Date is not in dispute, my lord. The dispute is one interview. It may be on the same date, but dispute is with regard to one interview wherein they have made two assessments, my lord.
Okay.
They say, because that was not known to me. Dispute is not with regard to the date, that on a particular date, that is 23/4/2022.
Yes.
My lord, we appeared before the interview committee. They have held only one interview committee in their affidavit. They have said. I'll just take your lordships to the affidavit filed by the Ames.
Yes.
135. Lordship will find the affidavit page 135.
Yes.
Para would be
144
para 11, my lord.
11, yeah.
139, page 139. Page 139.
That in respect to the statement by the
Yes.
11 and 12.
Same selection committee interviewed the candidates for both the posts, but separate assessments for each of the two posts were made by the selection committee. Same selection committee interviewed the candidates for both the posts. On 23/4/2022,
At 9 AM.
9 AM, same selection committee, panel of 6 members interviewed the candidates for both the posts. One exam was held.
What is there? It is their stand.
That is, one exam was held and two results came out. One is for associate professor, one is for assistant professor.
Not exam, interview.
Whatever may be, it's not a written examination. My lord, I am using this exam as a, my lord, normal sense that it's an exam. I'm not referring as written examination.
There
It's
is
an
all
exam.
There is all possibility that you are interested in associate professor's post. And therefore you have the.
No, I applied for-
interview for assistant professor in a very casual manner. Okay, no, I'm not interested. Maybe.
No, it was not, my lord, that was not the case. I applied for both the posts, associate and assistant. My lord, I was staying in Delhi in Safdarjung Hospital, my lord. I wanted to join AIMS. So I was interested for both the posts. So on the same.
Mr. Das, so according to you, is it a flawed procedure they have adopted by clubbing two interviews, according to you, clubbing two interviews, etc. This is a flawed procedure, according to you.
My lord,
You understand the query, no?
I understand.
Is it a flawed procedure or is the procedure correct?
My lord, my answer would be,
Please give an answer first.
yes, my lord, it's a
What is-
flawed procedure, my lord.
So on the basis of the flawed procedure, you want that you should be appointed. That is the mandamus you sought from the court and the court has given you.
My lord, I am
Is it
not-
permissible?
my lord, I
No,
am-
please answer the question. first.
I am on the decision-making process, my lord.
So ultimately, your submission is that it's altogether flawed procedure. How
Yes.
can they held an interview for two posts at one time? And how can they assess the capability of a person for two posts by one interview? That is absolutely, if you are saying,
Yes.
and it appears to be.
And this aspect
somewhat-
was dealt with by the honorable single judge, my lord. This,
The London single judge has dealt with this aspect.
Yes.
He should have cancelled all the appointments and asked them to have a fresh selection for that purpose.
my lord, and
In
this
that
submission,
flawed process, how can you be?
I understand your lordship's query, my lord.
Yeah.
You know, this,
That's
this submission,
Brother, this is Shyam has pointed out.
Mr. Das, hit the nail on the head or don't hit it at all. Your arguments are taking you towards a direction where you'll yourself face the flock. Your argument, the thrust is that the entire procedure was flawed. If that is so, the order of the learned single judge is not sustainable. That's what we are saying.
may I take your lordships to one paragraph of the honorable single judge, my lord? I'll just take.
Why don't you say what is it? You'll take us later, but
Yes,
tell us your story. What is your story? You're not been able to tell the story. You are showing this, showing that.
my lord, my
Tell us
story
in
is,
three
my
sentences
story
what
is
is it?
one-liner, my lord. My
What is
story
it?
is one-liner, that
Yes.
if a single examination is held, there cannot be two outcome. If I am arguing a writ petition,
Exactly. So it's a flawed procedure.
true, my lord.
You cannot be appointed. We'll set aside the direction to appoint you. You can't say that the procedure is illegal, so outcome of the process is appoint me. You can't say that. You can't argue against that. It's very, very straightforward. You cannot argue that. This is what you have argued, then the learned single judge is accepted. So unless you satisfy us on that, this is a legal debate.
Yes, my lord.
We are not going to go anywhere else. If the procedure is faltered, if it is flawed, if it is defective, how can you seek the benefit of that? And how can that benefit be given to you by a writ of mandamus? Tell us that, give an answer to that. If you can't, the matter is over. If you can, then we'll go into other aspects. A writ of mandamus is issued only to enforce what is the legal duty, legally correct, statutory sustainable. You can't say that something wrong has happened, so give me the benefit of that wrong. You cannot say that. You cannot argue against that. But that is what you are arguing. Therefore, we are asking you again and again, hit the nail in the head, or else we'll not go here and there. What is your case? What is your submission?
Lord, the learned honorable single judge, Lord, interfered on two aspects.
Yes.
First is with regard to this one interview, two assessment, that is. Second is that if a person who is selected for the higher post, that's why I was referring to para 20, para 20. Yes, my lord.
Yes.
On the facts and the circumstances of the case and also the admitted position, this court is of the opinion that offering appointment to the respondent number 5 and 6 to the post of assistant professor by allotting them more marks in a selection process consisting of one interview, including the post of associate professor, which is admittedly a higher post, and in which the petitioner was allotted more marks, appointment to the said respondent number 5 and 6 by the depriving the petitioner cannot be held to be justified. One objection was also raised in the category of assistant professor between the petitioner and the private respondents. There are other candidates also. This court is, however, of the view that the petition is based on the fact that it is the petitioner who had obtained more marks in the category of associate professor than the respondent number 5 and 6. And it is the respondent number 5 and 6 who have been given appointment in the post of assistant professor, and therefore the aforesaid objection will not stand. So my contention is that, my lord, I have scored more marks than the other respondents, the selected candidates in the post of associate professor. They themselves gave example in their affidavit.
But you have scored more marks in a flawed procedure.
Look, I approach this honorable court ventilating the grievances. I approach this honorable court praying for my appointment.
Yeah, we
So
understand.
so, my lord, that's why, my lord, the honorable single judge, thereafter also para 21.
Yeah. So the whole reasoning given by the learned single judge that a person who got more marks in the interview for the post of associate professor can't be given less marks for the in the post of in the interview of the post
One
of
interview.
assistant professor.
One interview. Given marks, he can be given marks. Marks difference can be there, but
Marks difference is one interview was there, then similar marks should be given to all the persons in both the interviews.
that is for the selection committee, how they give marks. But
So that is for the selection committee, how they give marks.
No,
Then,
no,
then
there
they
were-
have given the marks, then you are challenging it.
Firstly, Mila, there were no two interview boards. One interview board, 6 members, they ask questions A, B, C, D.
One interview for 2 posts, how can those interviews can carry different marks for 2 posts when the interview was 1?
Yes, Mila.
This is what your
Yes.
solution is.
Parameters can be different.
Marks should be similar.
Yes.
The marks you have obtained in the associate professor interview should be the marks in the assistant professor interview also. And vice versa, the respondent number 5 and 6 also same thing.
My lord, I'm not
should
on
have
that. I'm not on that. What I am on.
Not on that.
No, I'll just compartmentalize this, my lord. Lordship's query is correct that if a single interview is held and 2 posts are there involved, then same marks to be given in both the posts. My lord, the issue is that an interview committee was held, 6 members were there. Members asked me ABCD questions. I answered. 2 assessments came. It's not that 2 interviews were held.
2 assessments were came, yes.
So, associate professor was a higher post, 6 years and 3 years of experience. Assistant professor, 3 years and 1 year of. Lord, this is not a. This is not a Lord, a written examination. This experience, that's why I have taken your lordship to the experience. 6 years and 3 years experience, 3 years and 1 year, and same set of questions.
Suppose we just hypothetical situation.
Yes.
A person applied for 2. He applied for LDC as well as PO.
Lordship.
Again, same interview, and he got more marks for LDC and less marks for PO. And in any case, he was not selected for the post of LDC because some other persons have got more marks. then you can claim this of LDC के लिए I got 50 marks and for this peon के लिए 35 marks. Requirements are different, sir.
Parameters will be different.
Parameters are different. The LDC, the work which LDC is supposed to do is not supposed to be done by the peon, and the work which peon is capable to do, LDC certainly can't do that. It's
Qualification and experience had it been a written examination, my lord,
the peon is having very good qualification.
Lord,
in
had it been a
cleaning
written examination-
cleaning the floor, the LDC is not having that qualification. क्या करेंगे उसको? कैसे देंगे उसको marks?
had it been a written examination, my lord, I would have understood, yes, despite my so much of experience, my knowledge, educational qualification, I may have scored lower marks. But in an interview, you are holding an interview for two posts, one interview, you are assessing marks, you are giving more marks for associate, less marks for, Lord, and questions were same questions. This is not, Lord, perhaps with all due respect, my lord, I myself fail to appreciate, my lord.
Then why you are claiming appointment in this flawed procedure again? What?
My lord, since I have approached this honorable court by filing a writ petition, my lord, I was seeking mandamus that you give me appointment because the private respondents therein, their appointments were my lord, at fault. So that's why I sought for a mandamus that you give me appointment.
Something else?
My lord, that's, my lord, if some facts I have, my lord, not placed, perhaps, my lord, I have placed all the facts. Yes, my lord.
The facts are not under dispute.
Yes, my lord.
Facts are not under dispute. The only thing is whether these
But one thing is
marks to the respondent or the writ petitioner in the given facts and circumstances is fair or not.
One thing is absolutely clear, my lord, their submission that they have conducted the interview in successive sessions and two interviews were held. It's absolutely, it's absolutely incorrect, my lord. That's for sure. Rest I leave it to your lordship, my
In
lord.
fact, that is
I
the
am
correct
also-
position. Separate interviews were done, one after another, and separate questions were asked by the experts.
My lord, in that event for factual correction,
Just 1 minute. You see, the problem is happening because probably we are not using the expressions correctly. For two posts, the same interview board at the same time can hold interview, provided the parameters for testing the ability of the candidates are very well set out and different. Right?
It was different.
So successive or these are all use of English
Because some
expressions.
candidates have applied for one post only, so they were allowed to go. For those who have come for the second also, their separate attendance sheet was signed, then separate questions were asked.
So maybe it was not a great idea, but that itself is not a ground to.
Now we are in state of Assam, Lordship. We are having continuous day-to-day interview for APP and PP. So we are segregating because lot of candidates are common and there will be different parameters.
The parameters are different. it is
Here the number of,
permissible.
now we have about how many, Lordship?
Parameters of assessment.
Yes, parameters are separate also, and also because of the number of candidates, here the number of candidates is very few. And all the experts are coming from various parts of the country.
Look, where from the Milord, with all due respect, Milord, to the appellants, Milord, Milord, where from the appellants are submitting for the first time before the court that parameters were different? Where from they are submitting first time before the court that the questions were different?
No, it's not that.
Facts cannot.
You have to establish before the single judge that on same parameters, on same issues, just to fake a different interview, they have given different marks. You don't have the pleadings, you don't have the materials, there is no finding of the learned single judge, nothing.
That was my precise case.
No.
That was my precise case. They could not have assessed two assessments. They could not have come to it. I am arguing a writ petition before your lordships. There cannot be two judgments.
Yes.
So that was my precise case before the honorable single judge. my lord.
You can't be appointed then.
That lordship will
Can't be
kindly
appointed.
take care of, my lord, my folded hands. He comes to his native place so many years. My senior also said that she'll lose her job.
She
But
has
at the
lost,
same time- no,
she is from
no,
Pondicherry.
at that-
She
at-
was working in Kerala.
No, I just
She got a
explained
job
one
in
thing.
Guwahati.
I'm sorry.
Yes.
Honorable single judge gave a leeway also at penultimate paragraph.
You accommodate without disturbing appointment. of the-
Exactly.
Yes, that
Why
is-
the Ames is shying away from that?
That is for the aims.
No, that is
Appoint him.
why Ames is shying away from
Even
that.
then also he will not get. There are two persons above him.
That's the problem. And they are not
There
in
are-
parties.
They are
No,
not
no,
made
no.
parties.
Lord, this is not factually correct.
Now.
That is, nothing has been discussed either before the honorable
No,
single judge.
the-
My lord, everything cannot be
Let us
placed.
see. We will, what is the way out? We'll see to it.
Lordship,
Highly
Order
obliged.
is that? Arguments heard?
much obliged.
Order is that? Respondent number? Your selection has not been disturbed.
That is not in question, my lord. His appointment is not in, not question. But we have made him a party. He was there as a party, but because ultimately the.
One second. Mr. Das, as a young and upcoming counsel, you have to face onslaught from the court. Be
I understand, my
careful.
lord. And I'm thankful to this honorable court for putting questions so that I can learn more, my lord. I'm grateful, my lord. I'm grateful.